Good morning, everybody. Happy Super Friday. Welcome to TCF Live. Already got the day started. Barbara, thank you for two $5 super chats. Ashley, thank you for gifting us 5 memberships. I appreciate both of you. We'll get started with Judge Oakley.
Do you wait formal reading?
It should be ready.
Thank you. Good morning, Ms. Norton. All right.
Because I gotta get a name. Xavier, what's the last name, sir? Okay, can you remove your cover for me, please, sir? Thank you.
Can you find it?
I'm still looking.
Are you working?
Yeah.
Where do you work? How long you been with Waste?
Almost 8.
That's 29 years old, shooting there with technically negative family, was announced, has not dribbled since the date of the
Good.
state.
You want to put her on for the June 18th date?
So,
You want to put her on for June 18th? All right, I'll put her on a personal bond. You want to do it at 9 o'clock again?
thank you, Your Honor.
All right, Ms. Norton, thank you. Ms. Norton, I'm going to put you on a personal bond. The first 2 conditions are pretty obvious. Number 1, stay out of trouble. Number 2, show up for court on June 18th at 9 a.m. Third condition, do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's prescription. Can you abide by those rules? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw that up? You mess up on bond, you go to jail, it's going to cost you $1,000 to get out. Understood? Any questions? You're all set. We'll get you notice, get you out of here. Mr. Beaudry, come on up. Counsel, we've got the file.
192 Kiel, 649 on Southern Pier. Please tell the judge your name.
Thank you.
Bring my pre-trials, release, rest the arraignment or a show cause, set aside the show cause, as it relates to the arraignment, waive formal reading, plead not guilty. As it relates to the pre-trial, prosecutors agreed to dismiss the original driving unlicensed suspended subject to the benefit of guilty from the charge of a long-time person defended by rights.
Okay. All right, Mr. Beaudry, you understand those rights? You understand the options presented to you because of those rights? And you understand the possible penalty for the added charge? Understanding all of that, are you pleading guilty to that charge? Doing so freely and voluntarily? All right, did you drive a vehicle in Romulus on October 25, 25? Was your license suspended, revoked, or denied? Satisfied, counsel?
Thank you.
I'll accept the plea and dismiss the original charge. Tell me something about Mr. Beaudry so I can sentence today.
Defendant's 20 years old, works, lives with family, Your Honor, as a child on the way to sin.
Congrats.
His license has not ever had a license.
Mhm.
Appreciates that have it. This is gonna.
Okay, so when this hits his record, they're probably gonna resuspend him.
It's gonna be suspended for sure. He's being, we're aware of that.
Okay.
About that. So.
Where are you working?
Meyer warehouse.
How long?
Since November.
Full time? Good. What do they pay?
Nah.
You got to get a better job. What's the plan?
I'm kind of stuck there right now.
All right. What have you done besides Myers?
Worked at DTW. I think I cracked.
Okay, okay. How soon do you think he's gonna be able to get his license back? With this suspension?
And it's gonna, as soon as this hits, it's at least 30 days, so I can go back in there.
Is he eligible right now?
I believe he is eligible right
If
now.
if this case didn't exist, could you go to Secretary of State and get your license?
I would be, I
Is
would,
Greco here today or Angela? Angela. I'm gonna beat her up a little bit.
Yes, Judge.
I want to beat you up a little bit.
Okay, what's going on?
Mr. Beaudry's 20 years old. He's got a baby on the way. He needs to get a good job. I've got a real good job prospect for him, but he's got to get his license. And if he pleads to a no ops, he's 30 days out before he can get his license.
Okay, you want to do an allowing?
Will you?
Yeah, that's fine.
thank you.
All right.
Thank you.
This is going to be a nasty job. I mean, hard work, messy, wet, muddy. I think he's going to start you at 19 or 20 bucks an hour. He'll work you. He'll work you enough that you'll just go home, crawl into bed and sleep. That's what you need right now. Okay. You need to be working 60, 70-hour weeks while you're young and healthy. So when you're old and worn out like I am, you don't have to work so hard. Okay. Get your license straightened out. Call him first. Tell him I got that card from Oakley. I'm getting my license straightened out this week, whatever you can do. And I want to know if you can look at me to hire me. All right. And then let me know what happens. All right. So we're going to change this to an allow unlicensed driver to operate.
Thank you.
Okay. Now, what else should I know before I sentence?
20 years old, doing the right thing.
Right.
Southeast Michigan, no prior criminal record, all that good stuff.
I'm not gonna just give you your birthday present. I'm gonna give you your Christmas present too. Fines and costs on this file, $600, or show me a valid operator's license within 30 days. I'm paying you $600 to get your license. You understand how that works? Go away.
Judge, she has a bond. I don't know if you want.
Okay, I'm gonna keep $150 of your bond, and then I'm gonna pay you $450 to get your license. Go away. Good luck. Thanks.
Good morning once again, everybody. TCF Live on a Super Friday. It's good to have you all here. Lindsay, thank you for 10 gifted memberships. Ashley, thank you for 5 more. And Barbara, thank you for another $5. You guys are being very generous this morning, and I surely appreciate it. Let's continue with Judge Oakley.
Okay. Mr. Bowditch, how about, is it Mathis?
Mathis, yes, Your Honor. They run for the record, they have about appearing on behalf of, and this is Mr. Mathis, he's approaching. Sir, if you give Jeremy name, correct, please.
Michael Mathis.
Thank you.
Your Honor, today's date, time set for arraignment in this matter. Also, at this case, we are requesting an adjournment. We were hoping we could get on the June 18th docket.
Time?
9.
Mr. Mathis, is Lauren Graves somebody that you know, or is that a stranger to you?
Oh, sure, yeah, strangers.
All right, so no reason for you to have any contact with him. You saw him at McDonald's, you go eat at Burger King.
I already have.
All right. So I'm gonna order no contact.
Mathis.
Yes. THES. So no contact means no phone calls, no letters, no social media contact. You see him at Burger King, you're eating at McDonald's, you got it, no contact. I'll put you on a personal bond. Stay out of trouble, show up for court, and no contact keeps you out of jail. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw up on bond? Any questions?
Sure.
Have a seat. We'll get you notice, get you on your way. You're welcome. Jalen Estelle.
Right, Your Honor.
Did I pronounce the last name correctly? Thank you.
Your Honor, the court, Sheriff Ballot 45367, appearing on behalf of, and Estelle, sir, did you tell us the name?
Yeah.
Thanks. Your Honor, today's date and time set for arraignment in this matter, completed forward reading stand. We've also had a chance to pre-trial this case. You have an executed plea agreement, subject to court approval. In that agreement, Mr. Estelle will be pleading guilty to the charge of operating while physically.
Okay. Mr. Estelle, you understand your rights and the options presented? You understand the possible penalty for this charge, the added charge? All right. Understanding all of that, are you pleading guilty to the charge today freely and voluntarily? Did you drive a vehicle in Romulus on August 18, 2025 after consuming alcohol? Was there a breath test or a blood test?
I'm not certain about it. But this was all of a voluntary act by Mr. Estelle. He came in exactly claiming what happened.
Okay. Well, let's put it this way. Looking back on it now, on August 18, 2025, was your ability to operate your vehicle visibly impaired due to your consumption of alcohol?
Yes.
Satisfied? All satisfied.
All right. I've accepted your plea. I've dismissed the original charge. I'm going to send you downstairs to make a date with the probation department. You'll come back and be interviewed by probation. Based on the interview, they're going to do a report and recommendation. You'll go over that with Mr. Bowditch when you come back for sentencing. I will have looked at that report and then we'll have a conversation before I sentence you. Understood?
Yes.
Your bond is continued. No questions?
Judge.
No questions? Yes, Your Honor. Okay, I got that. Go downstairs and get, that's all right. Go down, bad questions, get bad answers. Go downstairs and get your dates.
I'm here with this holiday, have somebody that's want to be in here to be the her or warrant, have run them. She's just gonna send her over.
Oh, absolutely. Yeah, just add it in. What's one more? Darius Dunlap.
Ready? You're on the court record, you have time, hearing on behalf of, and you with Mr. Dunlap. Yeah, you make, let's see.
Good morning, sir.
Please take time. Reading the charge stand, also had a chance at this case. In this matter, Mr. Dunlap, we should plead guilty to an addict. No operator's license on person, with the understanding the original charge would be dismissed.
Okay. Mr. Dunlap, you understand your rights and options? You understand the possible penalty for this charge? Are you pleading guilty today to that charge? Doing so freely and voluntarily? Did you drive a vehicle in Romulus on April 10, 2025 while your license was suspended, revoked, or denied? Satisfied?
Satisfied, then.
I'll accept the plea to the added charge, dismiss the original. Still valid or still suspended? Are you valid now?
Just have to fix one cigarette off.
Good. Are you working? Where at?
I'll work for security though,
How long?
like 2 years.
Okay. All right. Looks like you already owe us some money on some other stuff. Are you on a payment plan on those?
I will be.
You can get that in place before you leave?
Yes, sir. Yes, sir.
Monthly, weekly? How you gonna do it?
Do it every weekly.
Okay, all right. All right, so the money I'm gonna assess today, you can just roll it all together. All right, what kind of shift are you on?
Nice.
So if I order work program for you, which means you pick the days and those days you have to be here at 8 o'clock in the morning for about 6, 7 hours, can you do that?
Yes, sir.
All right. I'm gonna order 4 days on the work program. All right, fines and costs, $600. I'm gonna send you down to the collections counter to set up your payment plan. So you're gonna owe us $1,310 and schedule your work days. Any questions? Good luck.
Barbara, thank you for another $5. Treats for Ellie. We'll add that 5 to her Treato fund. And Ashley, thank you for gifting 5 more memberships. Very generous this morning, all of you, and I surely appreciate it. Thank you so much.
Yeah, the record. Judge, everything on behalf with Mr. Manfred, we say anything.
Good morning.
Full reading the stand mute as pleaded not guilty for arraignment purposes. We have reached a resolution.
Tell me all about it.
The A matter, Your Honor, the expired license, and the B matter, 11 to 15, are both going to be dismissed. Or to be guilty to the amended charge of allowing an unlicensed driver to drive. And Ms. Bradley is the holder of a valid license.
Awesome. Awesome. All right, did you discuss your rights with Mr. Hadley? You understand those rights and the options they give you? And do you understand the possible penalty for this added charge? Understanding all of that, are you pleading guilty to the added charge freely and voluntarily today? Were you suspended on February 22nd? No. Were you expired on February 22nd, 2026 when you drove a vehicle in Romulus? Satisfied, counsel? So am I. Love the green and yeah, just very, very springy. Yeah, very springy. Well, the tie's nice. Anything else I should know before I sentence?
I kind of live with the allocution. I mean, she went out and took care of everything she needed to do. She's balanced good, otherwise.
Working?
Yes.
Where at?
Ready to get work.
Who for?
Here, right around.
How long?
2 years.
Good, good. All right, fines and costs are $400. Can you pay that today or do you need options?
2 weeks, that should be good.
You want me to just give you a due date?
Yeah, that's fine.
22nd, plenty of time?
Yeah. 22nd? Yeah. That's perfect.
All right. You're all set. Have a great day.
Thank you.
Thank you.
Wahoo, thank you for gifting a membership. Very much appreciate that as well. Thank you, sir.
Great trial. Yes, please state the record, sir. You have anything to miss? Your Honor, we'll adjourn this matter to review discovery, discuss options with the prosecution. We have reached a resolution. At this time, both original charges are going to be amended. The OWI will be amended down, operating while visibly impaired.
Yep.
Be tendering a guilty plea. The driving while license suspended will be amended down to a no ops. So we can tender a guilty plea to that as well.
All right. Mr. Hernandez, did you discuss your rights and options with Mr. Hadley?
Yes.
Did you understand all those rights and the options presented?
Yes.
You understand the possible penalty to the added charges? Understanding all that, are you pleading guilty to these added charges freely and voluntarily today?
Yes.
Did you drive a vehicle in Romulus on May 15 last year?
Yes.
And prior to driving, did you drink some alcohol?
Yes.
And at that time, was your license suspended, revoked, or denied? Was there a breath or blood test?
Test, and this one, that was actually part of the discovery. We had to look at, let's call it typo entry at the MSP that created a little bit.
Okay. Would you stipulate that the blood test result was 0.08 or more? You satisfied?
We are, Your Honor.
I'll accept the plea to the added charges, dismiss the originals. All right, I'm going to send Mr. Hernandez down to probation to schedule a pre-sentence interview. We'll get you scheduled with that interview and a sentencing date. The interview leads to a report. You go over the report with counsel when you come back for sentencing. I'll look at the report. We'll have a conversation. I'll sentence you then. Understood? I'll continue bond in the meantime. Any questions, sir?
No.
Have a lovely day. James, is it Belafat? Did I say it right? Mr. Belafat, are you going forward today without benefit of a court-appointed attorney? And you've met with the prosecutor and you made a deal, yes? Did you read your rights form? You understand all those rights? You understand the possible penalty for the added charge? Understanding all of this, are you pleading guilty to that added charge today freely and voluntarily? All right. If I take a plea from you to no valid operator's license on person, when we tell Secretary of State what happened today, they're probably going to suspend you for another period of time. You understand that? And understanding that, you're still willing to plead guilty? All right. Did you drive a vehicle in Romulus while your license was suspended on February 15 this year? I'll accept your plea to the no valid operator's license on person, and I will dismiss the original charge. Are you working, sir? Where do you work? How long you been there? Getting enough hours? Good. And what do you have to do to get your license back? All right, one ticket? Where at? All right, you on a payment plan with them? What do you owe them? What do you owe them? Okay. All right. If I order 4 days on the work program, can you get here 8 o'clock in the morning? All right, fines and costs on this file, Mr. Belafat, $500. Can you pay that today or need options? Go downstairs, set up some kind of payment plan, weekly, bi-weekly, monthly, whatever works for you. All right, I'll work with you on the money. Whatever you want to do, I'll work with you on the money. Go downstairs and set that up. All right, good luck to you, sir.
Tot, thank you for gifting a membership. Grandma TCF, thank you for gifting 5. I know I say this a lot, but I'm going to keep saying it because it's important to me that all of you know your generosity, the way you support me, the way you support this community, all of you, it is never overlooked. It is always appreciated. So thank you very much.
Infraction, double parking, and the misdemeanor would be dismissed. Is that your deal? And can you pay the $150 today? Calendar over there, if you can see the dates, tell me when you can pay it.
I get paid every 2 weeks.
That doesn't help me.
I guess it's gonna be Saturday.
Saturday? So are you getting paid this week?
No, hey.
So you paid the 15th. So you're gonna, yeah, I like Fridays. I kind of think in Fridays. So Friday the 15th, you get paid that week. So if I give you until the 22nd, you can get it paid?
Yeah.
All right. So we don't process this deal until we get our money. So if you don't pay it on time, then you're still dealing with the misdemeanor. Understood? Any questions? Have a lovely day. Well, Sadie White? Ms. White, are you going forward today without benefit of a court-appointed attorney? Did you read your rights form? You understand your rights? Okay. All right, we've got 2 files today. It looks like one, you made a deal with the prosecutor. You're going to plead to a double parking. You've agreed to pay $150, and we're going to dismiss the unregistered vehicle. That's from February 21. Then we've got another file. I don't know why this didn't get dealt with. Okay, we got another file. That's a Romulus from that same date. Drove while license suspended, revoked, or denied. Oh, okay, okay. Oh, she's gonna dismiss both of them. Ooh, that's a good deal. Okay. All right, and it looks like you already owe us money on some other stuff. What do we got here? On probation? Oh, you're on probation. Oh, you're on a delayed sentence for a violation of parental responsibility. All right, so you're okay there. You just got on that. Yeah. Okay, so when can you pay the $150?
When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you pay the $150? When can you p
You mean tomorrow? No, I've been gone all week for a conference, so it feels like Monday for me. So next Tuesday. I'll give you till Friday. I don't care. Okay. All right. So Heather, I'm going to dismiss the DWLS, which is the A, and then we'll reduce the B to the double parking. Okay, so next Friday, the 15th is your due date for 150. Any questions? You're all set. You're welcome. Irwin. Good morning, ma'am. Are you going forward today without benefit of a court-appointed attorney? Have you read your rights? You understand those rights and the options they give you? All right, let's see what the deal says. You're going to plead guilty to no valid operator's license on, no valid license on person. We'll dismiss registration or plate civil infraction, no insurance civil infraction, and drove while license suspended, revoked, or denied misdemeanor, right? You understand that when Secretary of State sees this deal, they're probably going to suspend you for a little bit more time. Yeah, they might resuspend you. You understand that's a possibility? Because this will show them that you were driving when you weren't supposed to be driving. You follow me? All right. And understanding your rights, understanding your options, understanding the possible penalty for the no valid operator's license. Are you pleading guilty freely and voluntarily? Yeah, but you're doing it because you decide that's the best deal for you, not because somebody's making you. Yeah. So did you drive a vehicle in Romulus while your license was suspended, revoked, or denied? That was February 19th. I will accept your plea and dismiss all the other stuff in keeping with your agreement with the prosecutor. All right, are you working? Where do you work? How long have you been there? Okay. Anything else you want me to know?
I want 2 kids,
All right, how old are they?
6 and 2.
So 6-year-old's probably in school. Okay. And what kind of shift you work on the job?
I work on 11:30 to 7:30, so throughout the whole day.
All right. So normally I would order work program, but that's going to cause you some extra problems. So instead of 4 days on the work program, I'm going to order 30 hours community service. What that means is charity work, literally any nonprofit. If you get inventive, you'll be able to find some place where you can go volunteer. The kids think you're taking them somewhere fun and you can kill a couple birds with one stone. Understood? And I'm going to give you until July 1. So go downstairs at the front counter, far end, ask them for the community service list, and we'll give you a list of organizations in our area that are pre-approved. You don't have to work from that list. You can find any nonprofit. If the IRS has them registered as a nonprofit, I'll accept the hours there. All right. If you're not working off our list, before you do the work, you might want to come in and have us confirm that the place you picked will approve, because you don't have time to waste doing 30 hours that I don't accept. All right. Fines and costs are $500. Can you pay that today, or do you need options on that? Go downstairs, front counter, where you get all that stuff. Any questions? Good luck.
Once again, everybody, good morning. It's TCF Live on a Super Friday. My name is Dan Soul, your guide through this journey through Courtlandia this morning. Barbara, another $5. Thank you, and the community and I love you too.
And the options you have and the rights that give you those options?
I'm not sure I fully understand.
Do you have any questions I can answer? Go ahead.
Being put over on revoke versus operating license on person. I just want to know.
The main, you mean the difference between what you're getting ready to plead to and what you're charged with?
What I'm pleading to and the original charge.
Yeah. So original charge, bottom line is the 2 points. The Drovo license suspended, you're gonna get 2 points from Secretary of State. With the no valid operator's license on person, you're not gonna get those 2 points. The Secretary of State may give you a longer suspension because this charge on your record, when that hits today, it'll show them that on February 12th, you were driving. So they might resuspend you, but it will not be points.
Okay. My situation, Your Honor, I heard that you my license was suspended for 5 years. And I made it to 4 years and 9 months, and they were suspended again because I got caught out doing revoke.
Right.
Work. That's
Right.
That's our goal is on work.
Right.
So they were suspended for another 5 years. So next year, we got 5th year, which altogether is like 10 years. I've been without a license.
Yep.
Like I'll completely turn my life around. I'll completely put down alcohol since the last incident and just been on the straight and narrow and to working home, literally. I missed out on family events,
Where you working at?
Bros Inc., New Boston.
Yeah, the lighting place. Yeah.
I just been on the straight and narrow. And beside that, like you catch lifts and Ubers, I got a bunch of.
Ton of money.
A lot going on. My kid got called over this summer.
Where are you going with all this?
Where I'm going with it is, and this reached the Secretary of State and they suspended another 5 years of 15.
Okay, stop there. Miss Manarino,
Yes, Judge.
Elijah Lee,
Yes.
DWLS down to no ops, February 12, 2026. He's been 10 years without his license because of drinking and driving charges. Last time he got an extra 5, it's because he got popped driving while he was revoked. I
Okay.
think the no ops is gonna do the same thing and add another 5 years.
So we amend it to an
He-
allowing?
He's a working guy, yep. he
Yeah,
works
that's
at
fine. We can do
Bros.
that.
All right,
Thank you, Judge.
thank you, Miss Manarino. She just saved you that 5 years. All right, so what you're gonna plead to is allowing an unlicensed driver to operate. So, you know, if you gave your nephew who's 15 your car and said, go up and get milk at the store, he's not licensed, that's the ticket you'd get. So that tells Secretary of State that you gave somebody the right to drive your car that shouldn't have. That somebody just happens to be you. Okay? Understood? All right, I think I got this already, but let's, February 12, 2026, were you driving a vehicle in Romulus? Was your license suspended, revoked, or denied? I'll accept your plea to the added charge. What kind of shift you work at Bros?
I work day shift. I work 6 to 2. I'll let work to come in.
All right, what days? Monday through Friday?
Monday.
They're working you 6 days? Good for you. All right. All right, usually I would do 4 days on the work program, but I don't want you to have to take work days off to do that. So I'm gonna convert your work days to community service hours. Did you hear me explain to the lady in front of you how that works? Did you hear me explain community service to the lady in front of you? It's charity work. All right, on the funny. That's money and fines and costs all rolled together.
It works.
On the money, fines and costs are $500. Can you pay that today or do you need options? Go downstairs, same counter where you're gonna schedule your or ask about 30 hours community service, if you want our list, is where you set up your payment plans. Looks like you owe us $90 on a 2022 balance due on that ticket. So just put it all together, one payment plan. Questions? You all set? Good luck with that license. Listen, when you're ready to go get your license, go talk to an attorney that does license restorations. It's gonna cost you money, but it'll save you time. Because what happens with most people that try it without a lawyer is they set up a hearing through the Secretary of State and they go to the driver's license appeal division. And the hearing officer says, okay, do this, do this, do this, do this, bring me that, bring me this, and then come back and see me in X number of months. If you see an attorney that does that for a living, they'll have all your ducks in a row. So when you go into the hearing, you probably get some privileges. It'll cost you, but I mean, how much does it cost you the last 10 years paying for rides? An attorney's a bargain. All right, so keep that in mind when you're ready. You're welcome. Good luck. Morris. Mr. Morris, are you going forward today without an attorney? Did you read your rights form?
Yes.
Did you understand your rights? Did you understand the options those rights give you today?
Yes.
All right, the deal says that you're gonna plead Morris.
Hey, we have 2 more.
Oh, is it Kiel?
Yeah,
Kiel? You're welcome. All right, so you understand your options, you understand your rights, you understand the penalty. So are you pleading guilty freely and voluntarily?
Yes, sir.
On February 19, 2026, did you drive a vehicle in Romulus? Was your license revoked or suspended? I'll accept your plea to the added charge, dismiss the original charge. Working?
No, not right now.
When's the last time you had a job?
September 2nd of 2025.
Where were you working last year? Where at?
Well,
All right. All right, so what's going on with the employment situation?
I worked in Part 3, September 2nd. I came home in December, kind of rough. Revenue was great prior to the school starts.
Yep.
School, I went to school in that.
Okay,
So.
where are you going to school?
School prep.
Morning, council. What are you doing there?
I'm going to school for sterile processing certificate and health sciences.
Okay, all right, good, good. And license still suspended?
Unfortunately, I was actually eligible to get it back. I didn't even know that. I thought because the points had ended up falling off, but they.
Right.
But I didn't call.
Yeah, and you know that this is probably gonna put you a little bit behind the gun. Okay, all right. Anything else you want to know? All right, and it looks like you already owe us money on some other stuff. A 2024 distracted driving.
I didn't know that I could set up.
Yeah. All right, so today's file is $500 and 4 days on the work program. Have you heard me explain the work program? You pick the 4 days, you show up that day at 8 o'clock in the morning, you're back usually 2 o'clock, 3 o'clock in the afternoon, done for the day. All right, so as on the $500, go down and set up a payment plan for that, plus the old distracted driving one.
I did already pay the ticket that was dismissed. Will they just take those fines?
The speeding ticket?
Yes.
When did you do that?
I did that yesterday morning.
Oh, all right. So can you just apply the 195 on that? Thank you, Elena.
I'll leave a note. I 195 on.
To the 500. Yes.
Got it.
Questions? Good luck. I got an arraignment file on that.
It looks like endurance in the.
Alrighty, friends. We've spent a lot of time with Judge Oakley this morning, but he was kind of on a roll. We might check back in later, but I'd like to put us in the Wayback Machine for a few minutes. This was yesterday after we ended our show. This is Judge Simpson. He had an interesting encounter with somebody. So
about it
let's give
yesterday.
that a look.
Okay,
I'll try and get it.
fine, I'll pass it.
Thank you, Your Honor.
But hold on for just a minute because it reset on me. Hold on. There we go.
I'll walk out.
You're doing those waivers. Okay, can you just double check those? Aye. Courthouse case of the people versus Hosea Hill.
Thank you, Your Honor. Alex Warren on behalf of Mr. Hill. Mr. Hill, can you state the court?
Hosea Raphael Hill. Good morning. Good morning. We're gonna need to deal with this violation.
Your Honor, I reviewed that with my client. At this time, he's going to admit to not only his behavior towards.
Why was he acting that way? You're gonna have to give me an explanation for that. Those folks over there at Community Corrections have to deal with a lot of people coming through, a lot of people that are under stress, and they don't need this garbage. And certainly, and I'll be honest with you, especially Ms. Dozier, does not need this garbage. So before you start talking to me, you better make sure you understand what you're saying to me.
And Honor, before the violation issued right after the terminated because of behavior at the intake. Mr. Hill came to my office.
We're clear. It's not just his behavior. She had to call officers in, try to deal with it, and still tried to do it, and he still didn't do it, and he didn't complete his intake. Go ahead.
My office, made me aware of what happened, sat down with me, wrote an apology letter to Agent Dozier, sent it to her. I extended my apologies on his behalf. And I think to try and put this into context, and he acknowledges there's no excuse for it, but to try and put it into context, Mr. Hill has had medication stolen. He's prescribed medication for a mental health diagnosis. As he scheduled 2 appointments with his psychiatrist to make a plan moving forward. And after sending our apology letter to Agent Dozier, one thing Mr. Hill brought up was if his social worker was present at the time of intake, I think that might help him regulate his emotions, but he's still trying to get back on the medication that he's prescribed. So
Let me just read the letter here.
well, Your Honor, I can answer any of the court's questions, and I think Mr. Hill can answer any of the court's questions as well at this time.
Please, I will answer. Please. Thank you. This is difficult. What's very difficult, what's going on. But please, I will answer whatever you need to know from me over here.
Over here.
I did not expect to go to that meeting and that happened. That's for sure. I'll be open. I'm an open person. And I was just opening up to Miss Dozier about my.
No, you weren't. You were interfering with the intake process. She was just trying to get certain things done.
Can I mention something?
Go ahead.
I was talking to Miss Dozier in a meeting, and there was some confusion. I was confused, and I was explaining to her why. Because the magistrate informed me that if I go to when I go to community corrections, because he ordered me to go there, and I did everything he told me to do. And when we were in court, when I was in jail, and we were in court, he mentioned about corrections, and I already have past experience with community corrections, so I understand that these things cost money. And excuse me, please, I'm not interrupting anyone, and I don't do that. So if I do, sorry. But once I was ordered to go there, I mentioned the judge in court. I said, Judge, I do not have any money. I just do not have any money, Judge. And he said, that's okay. Community corrections will not turn you away if you do not have any money. So when I went to community corrections and met with her in her office, I mentioned that to her. Because she mentioned that, I asked her, is this going to cost me? And she said, yes. And I said, okay, well, I don't have any money. And she mentioned that, excuse me, I'm trying to talk, sir. I am trying to talk to you.
Here's part of the problem. Your attorney is trying to save you. Oh, you know what? Don't throw your hands down. Bond revoked, adjourn next week. Take him.
Your Honor, we can come back next week on that.
Yes.
I appreciate that.
Oh, you better keep moving. I'll adjourn this out to the 14th.
Appreciate that, Your Honor.
Here's what I'm going to do, because I think they're going to devote all their resources there, and I don't have everybody in here. Court's gonna stay in recess.
So yeah, he had to take a recess because all of his staff had to go deal with that guy. So he had no security in the courtroom. Anyways, I thought you guys would appreciate that. So I thought I'd take us in the Wayback Machine there for a moment. Let's get back into today's stuff, and let's go back to Judge Oakley. He's still on a roll, it looks like.
Good morning. Okay, I don't know why they did that.
She brought it up.
Angela brought it in.
She also brought a register of action from down. I think she thought there was no file.
Okay, okay, all right. Ma'am, did you discuss or go over your rights?
Yes, sir.
You understand those rights and the options they give you?
Yes.
And do you understand the possible penalty for no valid operator's license on person?
No.
Up to, which means $0 to $500 fines plus court costs, and 0 to 90 days in jail.
Oh, are you know?
I'm not putting you in jail on this.
Driver?
Now, I will also say this. When this hits your record, Secretary of State may resuspend you for 30 days. Because this is going to tell them that you were driving on November 1 when they didn't want you.
Okay.
Understood? All right. So understanding all of that, are you pleading guilty to the added charge to them? And are you doing so freely and voluntarily? Ma'am, did you drive a vehicle on November 1, 2018 in Romulus?
I believe so, yes.
Okay. If I told you that's what the ticket said, would that ring a bell?
Yep.
All right. And at that time, was your license suspended, revoked, or denied?
So, yeah.
All right. Any reason to think that information was inaccurate? Okay. I'll accept your plea to the charge, ma'am. Are you working?
Actually, Your Honor, I just started a part-time position.
Okay, where at?
I was a Pomeroy here to be.
Okay, good. Good.
I'm working there part-time. And I get changed everything around.
Okay.
Abuse involved, I mean,
How long you been clean?
Your Honor,
Good for you. How? What are you doing?
in a recovery program.
Okay, what else?
I also get treated for mental illness.
Okay.
Seeing,
Psychiatrist? Good, good.
and then hence I started the job.
Yes. Yeah.
Things have really changed.
So you quit self-medicating?
Yeah, yeah.
All right, good for you. Keep up the good work. All right, keep up the good work. 78 days today? 978.
Days today.
Who's counting?
Oh, who's counting?
Yeah, good for you.
I appreciate that. Can you say one more thing?
You can say two more things.
I did not even, I hate to say it, but I didn't even know about this. I didn't remember. It was 7 years ago.
Because you were in the mess.
I was a mess.
Yeah.
I received the documentation in December, but I had a hip replacement. I got them in here as soon as I could.
Yeah.
I accept responsibility. I'm willing to pay anything. Just please don't throw me in it.
I'm not gonna throw you in jail. Here's what I'm gonna do. Fines and costs are $750, which I'm suspending in light of your 978 days clean. Go away. Have a lovely day. Good luck with the job. Yep, good luck with the job.
Run.
You as well.
Second.
Sure.
And he's muted himself. Okie dokie. Let's go to Florida, do our morning check-in with Wade Mercer.
Ms. Myrick, there is probable cause in the complaint, ma'am. Ms. Myrick, the criminal history I've got shows no prior history. Have you ever been arrested or charged with a crime before, ma'am?
No, sir.
Great. That's great. Ms. Myrick, listen to Mr. McDaniel and Mr. Bell, and then we'll address your bond or your release status. Mr. McDaniel, anything?
Just ask for conditional release, Your Honor.
Thank you. Mr. Bell?
We just ask for a reasonable monetary bond and with no contact with the property, which is Rent-A-Center.
I'm asking for your opposed to conditional release. What you're saying?
We're not opposed.
We'll leave it up to the
We'll
court's
leave it up to the
discretion.
court, though.
Yeah. Ms. Myrick, with that history, I'm going to give you a conditional release, ma'am, option. So you can pick between a bond and a conditional release. Some people actually prefer a bond. Your bond in your case would be $2,500 cash or surety. But I am going to offer you a conditional release because of your lack of any history, ma'am. You would have the standard conditions of release. And either way, you would have a condition of no contact with that rental agency or that rental company that you allegedly rented this property from. I think it was Rent-A-Center.
It was, Your Honor.
That would be the company you can have no contact with. So, Ms. Myrick, do you understand your choice between the bond and the release, ma'am?
Yes, sir.
And you prefer the conditional release, or would you prefer to post the bond?
Conditional release.
All right, I'm gonna grant you a conditional release. The jail's gonna, they're gonna let you get dressed in your regular clothes. They're gonna bring you to the courthouse because that's where the conditional release officers are at. You'll meet with Mr. Goodson or Mr. Ham when you get here. I know that we have a mock trial this morning. What time do you need her brought, Mr. Goodson? You want her brought at normal time, or what do you want to do? Yeah, we're short of conditional release officer this morning, Corporal. So instead of bringing her, we probably need to go back to the old way we used to do it. Can you bring her at 11 o'clock, Corporal?
Yes, sir, I can.
Thank you. So let me talk to your sister. So she'll be downstairs about 11 o'clock. The jail will bring her up here. She'll meet with a conditional release officer. They'll go over the release with her. They'll give her a chance to ask any questions. They give her all the rules in writing, and then she's free to go. Is someone going to be able to pick her up about 11? So your sister says they got transportation covered for you. So someone will be here to pick you up, Ms. Myrick, about 11 o'clock. And the other thing the jail will do is they're also going to give you a written notice for your next court date, which will be June 2nd at 8:30. That'll be in the circuit courtroom, and they'll give you that notice before you leave the jail. Ms. Myrick, do you have any questions?
No, sir.
In the courtroom, any questions? Do you have any questions? All right, Ms. Myrick, wish you the best.
Thank you.
We have Kendrell Brown next. Brown, good morning, Mr. Brown. You're here because you've been accused of one count of battery on a law enforcement officer. Mr. Brown, there is probable cause for the charge, although it's a unique fact pattern alleged. Mr. Brown, I think you're entitled to a bond. I think you also just got released from jail, I believe. So let me listen to the attorneys and I'm going to address your bond status. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell or Mr. Bell?
Your Honor, we would just be requesting a monetary bond and no contact with the big and little. Mr. Brown did get out of jail, I believe, about 2 weeks ago.
Is there
He was trespassed.
so there's a trespass warning there. So the big little's not actually the victim in the criminal case. The victim will be the law enforcement officer. Okay, so Mr. Brown, what I'm going to do is I'm going to set your bond of $7,500 cash or surety. You do have a condition of no contact with that business, sir, where this allegedly occurred because they've already asked for a trespass warning. You can't go back there. Mr. Brown, the jail will give you a notice for your next court date, which should be June the 2nd at 8:30. And Mr. Brown, you will get a chance to use the phone in just a few minutes, sir, to try to post the bond. Mr. Brown, do you have any questions? No questions? Have a good day. Christopher Sanders. Mr. Sanders, good morning. Mr. Sanders, you're here because you've been accused of multiple charges. Let me tell you what you've been accused of. 2 counts of possession of firearm by a convicted felon, 1 count of possession of ammunition by a convicted felon, 1 count of possession of actually it's not possession, that's misnamed. 1 count of displaying or carrying a concealed firearm during the commission of a felony. Those are all second-degree felonies. Then you have tampering with physical evidence, a third-degree felony, possession of meth and possession of cocaine, both third-degree felonies, and resisting a law enforcement officer without violence, that's a misdemeanor. So you have a total of 8 charges, 1 misdemeanor, and 7 felonies. There is probable cause for all 8 charges. I did take a look at your criminal history, and it appears you've been to prison 10 times. Getting out most recently in 2019. Obviously, that's going to affect your bond. Mr. Sanders, I'm going to listen to the attorneys, and I'm going to set your bond in these cases. Mr. McDaniel, anything on behalf of Mr. Sanders? Mr. Bell.
Your Honor, given the defendant's criminal history and the charges in nature, we request a higher bond, and also that he be subject to random urinalysis.
Thank you. So, Mr. Sanders, I want to set your bond at $25,000 each on your second-degree felonies. You have 4 of those. No. Yeah, you have 4 of those. The third-degree felonies, the tampering, the 2 controlled substances, those 3 will be $10,000 each, and then $5,000 on the misdemeanor. When you add those together, you get a total bond of $135,000, if my math is right.
It is, Your Honor.
$135,000 bond, cash or surety. You do have a condition of random urinalysis. Mr. Sanders, that means you could be drug tested if and when you do post bond. Mr. Sanders, you also will be given a notice for your court date. Your court date will be June 2nd at 8:30. Mr. Sanders, do you have any questions, sir? Yes, sir.
I have a concern of the marriage of the incident. It's not my vehicle.
Okay. I wouldn't talk about the charge that you're accused of, but the allegations are that you had firearms in the vehicle and that you actually took one of the firearms out and got out of the car with you when the officer, it could have been a lot worse situation from the way the complaint reads, that they told you to leave the vehicle, the firearms in the car. And according to the complaint, you got out with one of the firearms in your hand, and the officers, I don't know if they had their weapons drawn or not. They probably did. And then you threw it across the road allegedly. So whose vehicle it was is a minor part of this. You've got some very serious charges. Do you have any questions, sir?
So my bond is set for $130,000, you say?
$135,000 bond for the 8 charges you have. Yes, sir.
So what I got?
John Wilson. Mr. Wilson, good morning. Mr. Wilson, I think you were held 7 days for Marion County to see if they were going to file a violation of probation. I looked in the file this morning in Marion County, and I see no affidavit filed and no warrant filed. Mr. Mitchell or Mr. Bell, do you agree?
I agree. I haven't seen anything.
So, Mr. Wilson, I'm going to release that hold for Marion County. That this doesn't mean they won't violate your probation. You've had a recent violation of the probation within the last month. That may be playing into this. I don't know. But right now, there's no warrant for you, so I'm not going to continue to hold you. Mr. Wilson, you have the right to post the bond that was set for you. If you post the bond that was set, you'll be released. Mr. Wilson, do you have any questions?
No, sir.
Have a good day, sir. We have Markeem Romeus. Good morning, sir. You're here because you've been accused of 1 count of burglary of a structure or dwelling causing damage in excess of $1,000, grand theft between $750 and $5,000. Those are the 2 charges you have. There is probable cause in the complaint. I've also looked at your criminal history, which you've got a couple of charges. It's not horrible criminal history, but you've got a very serious charge. One of these is a first-degree felony. That burglary charge is a first-degree felony, so it's a very serious charge. I think you're entitled to a bond as far as I can tell. But let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
Nothing, y'all. Just take into account criminal history.
Thank you. Mr. Bell?
Your Honor, we just be requesting a reasonable bond and no contact with the property.
Thank you. So, Mr. Mayor, I usually set a $50,000 bond on first-degree felonies. That's what I'm going to do in your case. Your bond's going to be $50,000 on the burglary, $5,000 on the grand theft. Your total bond is $55,000 cash or surety. You have a condition of absolutely no contact with that property that you're accused of burglarizing. You cannot go to that particular pharmacy that you're accused of. Mr. Ramirez, you'll get a chance to use the phone in a few minutes, sir. If you post the bond, you'll be released. You also will be given a notice for your court date, which should be June 2nd at 8:30. Do you have any questions, sir? All right, have a good day, sir. Next is Christopher Bell. Mr. Bell, good morning. Mr. Bell, you have the same charges as your co-defendant. You're charged with one count of burglary of a dwelling or structure causing damage in excess of $1,000, one count of grand theft between $750 and $5,000. Now, Corporal, in the packet, there's a hold
Sentenced to prison.
where Hillsborough County State shows him being sentenced to Department of Corrections, but there's no hold on the jail sheet. I want to make sure y'all have that.
Yes, sir, we got it. I put it over to the side on the docket.
I do see it over there. It's on the far right. Thank you. So, Mr. Bell, you do have a hold from the Department of Corrections. I think you've entered a plea and been sentenced to 3 years is what it looked like when I opened that up. So just be aware of that. You're still entitled to a bond here. There's no point in posting it unless you just want to go on the DOC. If you post bond here, you go to DOC, but you're entitled to a bond. So I'm going to set you one. Mr. McDaniel, anything on behalf of Mr. Bell?
No, Your Honor.
Mr. Bell, anything on behalf of the state?
Your Honor, we would just be requesting, it's a formality at this point, but no contact with the property, given his DOC sentence.
So, Mr. Bell, your criminal history is much worse than Mr. Romeo's. Your bond's gonna be $75,000 on the burglary, $10,000 on the grand theft. Your bond in Jackson County is $85,000. You do have a condition of no contact with the property that was allegedly burglarized. Mr. Bell, do you have any questions, sir? June 2nd will be your court date at 8:30. I looked at it and I'm pretty sure it is because I put it in this. Let's double check. That's the way it is on the warrant too. Yeah. It's Christopher, not Christopher. Is it? We have Lori Lukitas. Ma'am, good morning. You're here because you have 2 out-of-county warrants. I think they're both violation of probation warrants and they both have no bond on them, ma'am. So what's going to happen is you'll go to either Washington County or Calhoun County next and see if you can resolve this. And if other county still has a warrant on you when you get through with the first county, you'll then go to the second one. But both counties have no bond warrants. Do you have any questions, ma'am?
No, sir.
All right, ma'am. Wish you the best.
Thank you.
Yes, ma'am. We have Tiffany Eubanks. Eubanks, good morning. You're here because you've been accused of 2 counts of uttering, 1 count of grand theft, and then there are 2 charges that are left off of the jail sheet. Mr. Corporal, there's a complaint in here where they served these warrants yesterday. There was a possession. Actually, I don't think they're warrants. When they made the probable cause arrest yesterday, they had a separate complaint in the packet that y'all sent me for possession of meth and possession of drug paraphernalia. So you actually have 5 charges, 2 utterings, 1 grand theft, 1 meth, and 1 paraphernalia. 4 of those are felonies and 1's a misdemeanor. So the jail sheet's wrong, Mr. McDaniel. Ms. Eubanks, I did take a look at your criminal history, which was perfect before this. What I've been provided shows no prior criminal history. I think. Let me check and see. There was a drug paraphernalia. Is that this one? No, that's this one. Yeah, I showed nothing before this. So I think you're entitled to a bond, Ms. Eubanks. I'm going to listen to the attorneys before I set that bond. Mr. McDaniel, anything on behalf of Ms. Eubanks? Thank you, Mr. Bell.
I was going to let the court know that there are 2 misdemeanor review cases stemming from her involvement with the other Eubankses that we have seen also. I just want to bring it to the court's attention, but as it pertains to the 5 charges she has today, we're requesting no contact, obviously, and random UAs.
Thank you. So, Ms. Eubanks, I'm going to set your bond at $5,000 each on your felony charges. There are 4 of those. $2,500 on your misdemeanor paraphernalia, ma'am. That makes your total bond be $22,500. Cash or surety. You have a condition of random urinalysis, and you also have a condition of no contact with the alleged victim in the uttering case, uttering and grand theft case. Ms. Eubanks, you have the right to use the phone in a few minutes to try to post the bond. And Ms. Eubanks, you also, ma'am, will be given a notice from the jail for your court date, which will be June 2nd at 8:30. Ms. Eubanks, do you have any questions?
Just doing the time.
Or what was the total amount again? 22.5. Okay.
Nothing else. Mike Murphy.
Or the review or the additional two? Possession of meth and possession of paraphernalia.
Mr. Murphy, good morning. It's the State versus Mike Murphy. Mr. Murphy, you're here for a new charge of trespassing. Mr. Murphy, there is probable cause in this complaint. You're already on probation for a separate trespassing. So this morning, the probation office filed an affidavit of violation of probation. I signed a no bond warrant. So we need to get that warrant served on you first so we can get the warrant out of the system. So please listen to Sergeant Applewhite. Mr. Murphy, let's get this warrant served and then we're going to try to deal with these cases. Mr. Sergeant Applewhite.
Thank you, Your Honor. This is Sergeant Gary Applewhite with the Jackson County Sheriff's Office. Are you Mike Murphy?
Yes,
Is your date of birth October 24th of 52?
yes, sir.
Mr. Murphy, I have in my hand a copy of the arrest warrant that has been issued to you for violation of county probation. Understand that this warrant is now served on you and a copy of this warrant will be provided to you before the end of business today.
Thank you. So that's the reason we do it that way, Mr. Murphy, is I don't want you getting picked up 2 or 3 or 4 or 6 months from now on an old warrant. So we did that just to get that warrant served and out of the system. So you're accused of violation of county probation and you're accused of your new trespass. I'm appointing the public defender's office to represent you. Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Murphy. He's going to plead no contest to the charges listed and admit the violation of probation at 25,452 MM. Understanding he'll be sentenced to 4 months in the county jail, be a $370 fine. In new case, remaining fine owed in the old case, 1-day jail credit. This will resolve his case. He signed his 2 form waivers right to 3 trial and call witnesses. All run concurrent.
Thank you, Mr. Goodson.
And the original fine balance on his a violation of probation is $290.
$290. And Mr. Bell, is that all agreeable with the state?
It is, Your Honor.
And Mr. Murphy, did you hear that agreement, sir?
Pardon?
Did you hear that agreement, Mr. Murphy?
Yes.
And Mr. Murphy, is that the plea you would like to enter?
Pardon?
4 months, say yes.
Yes.
Okay. Do you have any questions, Mr. Murphy? Mr. Murphy, do you have any questions? Any questions?
No, Your Honor.
Okay, Mr. Murphy, I'm going to accept your plea of no contest to the charge of trespass and the new charge. I'm also going to accept your admission that you violated the terms and conditions of your probation and revoke that probation. Both sentences will be the same. 4 months in the county jail, adjudicate guilty, concurrent with each other, 370 court costs and fines. In the old case, you have 290 left. So that's the total court costs and fines. You have credit for 1 day served on both cases. Those will be reduced to a civil judgment if you don't get them worked off at the jail. So, Mr. Murphy, you have a total of 4 months, but hopefully you'll get you some gain time through the trustee program and not serve that whole time. Mr. Murphy, do you have any questions?
Your Honor.
Wish you the best, sir. Mr. McDaniel, I think that's it for public defenders for first appearances, unless I missed something. Anything else from the public defender's office? You're muted. I think you're muted still.
No, Your Honor.
And Corporal, anything else in the jail?
No, sir.
Mr. Bell from the state.
No, Your Honor.
Mr. McDaniel,
All right,
I know
that
that
takes-
you have something after this because you're not able to do the mock trial thing. What time does that start, Mr. McDaniel?
I got to go do some.
All right. Anyways, that takes care of that court. Let's go up to, let's go to Michigan, Judge Elmore. See what's going on over there.
Good morning and welcome to the 28th Circuit Court here in Westford County. And we begin today's docket call by taking up the case of People of the State of Michigan versus Michael Joseph Calouette. This is file number 26-14185-FC. Appearances from counsel, please.
Good morning, Your Honor. Erin House on behalf of the people.
Thank you.
Your Honor. Thank you, Your Honor. Taylor Anna Fiervento on behalf of the defendant who is making his way across the table now from the jail area.
All right, thank you very much. Mr. Calouette is now being escorted here to the courtroom and is now seated at the defense table. We are here today for two issues, at least initially. The first one is a final pretrial conference. This case is currently set for trial on May 26th, if I recall, or at least to begin on that date. And we also have a bond motion by the defense. Oh, wait, hold on. No, actually, I know
We would like some motion on the record today, Your Honor.
I was reading the other line above it, but I know we got a motion for that today as well. So let's first cover the final pretrial conference portion. I met briefly with counsel in chambers. I know there was some other talk going on. Ms. Fiervento, do we have any resolution to enter in the record today?
No, Your Honor. There was a offer that was sent over. I reviewed it with my client. My client is rejecting it. That offer would be to essentially plead guilty to 2 counts of CSE first and 2 counts of CSE second. There were some other considerations there for sentencing and things. My client is a hard no on that.
Okay.
We would like to proceed to trial on the 26th, and I know we have to address the issue of the prosecutor's new motion that was filed, I believe, on Tuesday.
All right, well, let's take a look at it. Now, I don't think the people filed the motion.
I'm sorry, notice.
I got it. But they did file a notice of intent to present evidence at the trial pursuant to MCL 768.27B. When we were last on the record, I think we were, yeah, it was here when we were here for the motion on the expert witness, if I recall. And we talked about government let us know that there might be some reason to extend it out as they were continuing to conduct investigation, or at least their law enforcement officers were. I said, well, we're not going to adjust any dates now because I wanted to keep the pressure on law enforcement to complete their investigation. This information that was filed on May 6th, as far as I know, is a culmination of that investigation, placing the defendant and defense counsel on notice of the details. So next question becomes, what do we do? Is there going to be a motion in limine filed by the defense? Which you might. Sorry, I just let the airplane go by. Which really would be a motion in eliminate by the defense. So we can call it a response, but really it's a motion to be filed by the defense. So does the defense elect to file and have a hearing on the admissibility of that evidence?
Yes, Your Honor, and I could get that in, I believe, by Tuesday of next week.
Mhm.
There is some stuff in there that's new, but a lot of it is things that we expected already, and it's similar to what was back at the preliminary exam.
Okay.
Thank you.
All right. Well, I know next week I am in Lansing on Thursday, and I am on a semi-vacation on Friday and the following Monday, Tuesday, and Wednesday. So I know we're going to have some limited time as a hearing, and that's going to take, next Friday would be the 15th. So we know we're pushing into toward the end of May. One moment. Yeah. So unless we have a hearing on Wednesday, the 13th next week, which I believe I have quite a bit of availability. The other is now we're pushing the hearing into the last week of May, which is when the trial is currently scheduled. All right, so I'm going to turn it over to Ms. House. Ms. House, you and I sorry, we all spoke in chambers about some availability of witnesses and potentially a request to adjourn by the defense, adjourn the trial, I mean.
Not by the defense, by the people.
I'm sorry, by the people. Thank you. I apologize. Go ahead, Ms.
Your Honor, the notice that I filed is lengthy. It's 34 pages long. It goes into very specific detail about prior acts of domestic violence that the people intend to present evidence of that the defendant started committing, excuse me, in 2003 to 2008 with the mother of 3 of his children, and then between 2010 and 2019 with the mother of the victim in this case. So 768.27B allows for admission of domestic violence evidence in sexual assault trials and sexual assault evidence in domestic violence trials. But that is a little more unusual than sometimes when we admit domestic violence evidence in a domestic violence trial and such as that. So I certainly want to make sure that we're protecting all of the defendant's rights in this situation. So
and while it's not an automatic admissibility, the court is still required under 768 to do a 403 analysis. So therefore, it almost requires or demands the court to review them. All right.
yes. So there are those issues, and then obviously whatever the result is of the court's decision in terms of whether all of this evidence, some of this evidence, none of this evidence will be admissible trial is also going to probably impact both the defendant's decisions about whether he wants to accept the offer or go to trial, as well as it could affect whether the people want to make a different offer at that point. So my concern about pushing this so close to the trial is that I don't know that it leaves enough time for all of that to occur. I also am not sure whether this court is going to want all of our other acts witnesses to appear and testify. Is that an evidentiary hearing, or is it simply a hearing where I, as an officer of the court, make an offer of proof about what I believe that these people are going to testify to? That may impact how much time we need to be able to conduct that. So I just have a concern that to thoroughly address this, to make sure that we are, not proceeding to trial on anything that we shouldn't, that we protect the defendant's rights. It just doesn't seem to make sense to me that we're going to be able to get all that done in a meaningful way and then afterwards negotiate before a trial that starts on the 26th.
All right. As far as an evidentiary hearing, it's up to the people as to how they present that evidence. It could be by an officer of the court. However, I would say it should be something more than that, because I think I need to have some evidence to be able to consider it. That could then come either through a live witness testimony or other things such as police reports, recordings of interviews, things like that. But that's all up to the people. I'm not going to tell them how to present it. And then if the defense wishes to have those witnesses here, that could be something you all take care of. All right, so I'll also note that this were these witnesses added to the witness list?
Yes, they have been,
Okay.
Your Honor.
All right. Were they added within 28 days of the trial date, or were they added when you submitted the notice?
They were actually, I filed the new witness list this morning.
Okay.
And it does include these new witnesses. Some of them were on a witness list that we had before.
Yep.
I think it's just the new witness CVS,
Okay.
who we didn't know about before.
All right. So that means we are within the 6 to 28 days of trial. So I assume therefore the people are requesting or motioning the court to permit the additional witnesses outside of that 28 days.
Yes, Your Honor.
All right. Thank you. Yes, ma'am.
I was gonna say, we are not within the rule for the 28 days, and we would object for CVS.
Yep.
As for Ms. Barkley, again, her testimony was at the preliminary exam. I wouldn't say that this is necessarily a surprise that this is being filed. That said, I would emphasize the fact that there have been prior requests by the people to adjourn that May trial date, and my client has refused. My client wants his day in court. He's demanded his right to jury trial. The fact that this is being filed while it's within the 15 days, it feels with this additional evidence from CBS, which again, could have been obtained at any other point. We're almost at 180 days for speedy trial. It feels like a backdoor attempt to try to strong arm my client into an adjournment because the people are not prepared for trial, instead of being an actual legitimate attempt to bring in 2017. Thank you.
Well,
Just to be clear, this new witness was interviewed the week prior. I didn't receive the report until 7 p.m. on Tuesday night. And then I completed drafting my motion and filed it, I think 11:30 a.m. the next day. So I did the best that I could on that, but I don't have control over when she got interviewed, and there was a delay in getting the report to me.
all right. First of all, the argument here against the modification of the witness list, which is really the question, is somewhat circular. It wasn't an unfair surprise, therefore there is no unfair prejudice. And everybody knew about it, but they were just getting the statements. Now, the alternative could have been, and maybe the defense would have liked it or probably not liked it, gone to trial without a statement. They don't have to go get police statements or interviews of a witness. They can just list witnesses and never have a report statement, which probably defense attorney wouldn't want. You'd probably want that statement, right? To prepare to cross-examine a witness.
Your Honor, I think there is some confusion. There were two witnesses listed in the notice. One is Miss Barkley, who we have known about since prelim and who testified at prelim, and we had statements from her at prelim. The other is CBS, who is newly disclosed.
Right.
So if the question is unfair surprises to CBS, very likely that could be an argument. But again, we're in a catch-22 because there is no reason the people could not have interviewed CBS way before we were close to the 180-day mark.
Okay.
Why are we wait? I understand the situation. There's no reason this notice couldn't have been filed sooner. It's within the,
Okay, I'm sorry. Go ahead.
this is,
Mhm.
defense is in a catch-22. Because if we agree to the adjournment, my client is sitting here, his wife is due to give birth to their child any day and she's having medical complications. On the other hand, we don't go forward on the 26th.
Mhm.
Or I'm sorry, we do go forward on the 26th and we're potentially at this disadvantage. I've talked to my client about the pros and cons. He wants to go forward on the 26th. He doesn't want this further delayed. He claims he is innocent. And at the end of the day, the evidence is it's a pure he said, she said type of case.
Okay. All right, so let's go back to it. The fact is that, am I correct? You've all known about CVS for a while?
Not CBS. We've known
Okay,
about
about
Ms.
the other
Barkley,
person.
TB.
All right.
We've known about TB. We have not known about CBS.
So how is there evidence to suggest that the prosecution was not exercising due diligence to get CVS if nobody knew about CVS until recently?
The defense didn't know about
The
CBS.
prosecution.
I don't know when the prosecutor found out about CBS.
Well, that's got to be the argument. The argument to say that you feel like this is a backdoor or some kind of tactical advantage or disadvantage. There's no evidence that it is an intentional or negligent delay in finding something out. So I don't understand.
That would be a
where-
question for Ms. House when she learned about CBS.
But she just got the report. Now, keep in mind, the other point here is you could have just added when did you add it to the witness list?
Well, I just added it today,
Oh,
because I
today,
was
that's
waiting
it.
for the court to rule whether she could or couldn't
Yeah.
testify, but then I thought I better just
Yeah.
add her
Yeah.
presumptively.
Yeah. Well, this is one of those instances where if I say what I think, which I think I'm required to because I need to establish the reasoning of my ruling, somewhere down the road, somebody who is sitting at Sado is going to go, oh my gosh, in his ruling, he gave legal advice. Now, I'm not trying to give legal advice and I'm not trying to be injudicious. Let's think about this. Let's say I don't allow CVS. I highly suspect that Ms. Fioravento is going to cross-examine witnesses. then does that become the CBS become relevant in rebuttal? I also don't know what witnesses the defense is going to present. Are they going to present any witness that might say that the defendant would never do this? If they did, it becomes rebuttal evidence. You open the door. Now, for you all to probably make an educated decision about what questions to ask and not ask, specifically on the defense, it seems like you would want to have the police report. So they had to have time to gather the information to be able to get the police report. Now, Ms. House would have had the choice a week or 2 weeks ago to just add the witness to the witness list, and I would have approved it if it was within that, within the 28-day rule. And she didn't have to go get it, but she went out and got the report, which helps the defense be prepared. Therefore, I find that there is no unfair prejudice or surprise. In fact, it's quite helpful to both sides in establishing their cases in chief, both the direct and the cross-examination. Therefore, the court grants the oral motion to amend the witness list outside of the 28 days. Okay, now the next question is about adjourning the trial. I believe we talked about, and that's to be, and I don't remember if you've already raised that, Ms. House. You may raise it.
Yes, Your Honor. So I guess I didn't say the specific words, but due to the
I couldn't remember if you did.
Yeah, so due to the timing of this, I'm just saying that I'm concerned for protecting our appellate record, that we not rush through something that could be, that this is very significant evidence. If this comes in at trial, this is going to be incredibly damning to the defendant. We want to make sure that we only let in what's appropriate, what the court deems to be appropriate. The court's going to need to make a ruling about whether evidence going as far back as 2003 can come in. If I need to have all these people testify, I will need some time to find out when they're available and to do that. If the court instead wants to review recorded interviews, that we probably have,
That's all.
I would imagine it's like 8 hours of recorded interviews.
That's all up to you and how you all present it to me, whether it's in an interview. And if, let's say, for example, you were just to provide to the court a police report, or even just the witness of the officer who investigated it. I would expect the defense to maybe object. So it might be that I need to look at the actual interviews. That's all up to you all. I'm just sitting here waiting to call balls and strikes. Okay. Ms. Fiorvento, your response as to the request to adjourn the trial date.
Thank you, Your Honor. We're going to object. And before going on the record today, I did talk to my client about the pros and cons of objecting in light of this 27B. He's in a catch-22. And I've mentioned this already. On the one hand, if he agrees to this adjournment, he continues to sit in jail. His wife is due to have a baby any day in a complicated pregnancy situation. And he's here away from all of that. And he's already close to his 180 days. On the other hand, I understand the court's concerns.
When does his 180 days run?
I have that he's at 150 days from his bond date as of today, but I believe he was picked up an extra day before that. If I may, what was the date they picked you up again?
The 18th of November, 170 days today.
He says he was picked up on the 18th of November, and I'll run a calculator on that.
According to the
19th of November, I'm sorry.
Okay, hold on. According to the Register of Actions from the district court, he wasn't arrested until December 8th. Where was he between November 19th and December 8th?
He was living out of state.
See, the offense date happens to be November 19th of 2016. So when did he get arrested out of state?
He says November 19th of 2025.
Okay, I'm going to need some proof of that. Because right now, according to the court files, he was not arrested until December 8th.
Again, even if we're arrested on December 8th, which is what my records show, that still is 150 days as of today, which means if we adjourn out, we are going past our 180 days.
Were there any adjournments of the case while the matter was in the district court?
That was Mr. Hertel, Your Honor. I
Yeah.
do not know.
I think there was a brief, the preliminary exam was scheduled initially for December 23rd, which is right before Christmas.
And
And
then
so
the
we
parties-
stipulated,
And the
for-
parties waived the 21 days and it got pushed out
I think it was
to,
the 13th of
Yeah.
January, maybe.
yeah. So you got a 2 to 3 week gap there. So you actually, whatever number you calculate, add at least 14 days.
Even then, Your Honor, if we're adjourned, we are gonna go past that 180 days.
Well, I don't know that because I don't know when he was actually arrested on it. But if, let's say that he was arrested on the 8th of December.
That's 150 days as of today.
Yep. That means at least as of today, we have another 30 days left. And then if I add the 14 days for the days that you all agreed by stipulation to adjourn the preliminary exam, I'm now at 65 days, which puts me into the middle of the end of June, beginning of July almost, yeah, end of June. So we have 6 weeks to go to trial. So his 180 days trial clock is not there. All right, plus I would have to have evidence that, because if there is unavailability of witnesses despite the exercise of due diligence, things like that, the court can consider an extension beyond the 180 days. But I want you to be careful, and I'm also concerned about the appellate issue. If I forced you to have the hearing next Wednesday on the 768 information, I'm going to make that ruling probably that day or the next day, which I'm not even in the office. I'm really concerned that you're not thinking about the appellate issue. I guarantee you, and I don't know what the evidence is yet. I haven't read the preliminary exam, and I have not yet read Ms. House's 768 notice. I guarantee if there were a conviction, the very, very first thing an appellate defender would do is file a claim of ineffective assistance for not agreeing to an extension when there's easily another 6 weeks of time to be better prepared for the new witnesses. Now, unless you're going to tell me that there's nothing in what the 768 stuff says that is a surprise, including CBS, I don't know why I wouldn't grant it.
Your Honor, I have spoken with my client about the pros and cons of the decision to push for the May 26th date versus to agree to the adjournment. He wants to push for the May 26th date. Your Honor's concerns are things we discussed.
Yeah. Well,
He wants to push for the May 26th date.
okay. Well, I think I have 6 weeks of flex time. And we got today's the 8th, the trial set for the 26th. I've got I've got at least 3-4 weeks of time before I'm even at the 180-day trial clock window. Plus, I don't have any evidence today presenting that there was a lack of due diligence. One moment. Let me just see if I have any other factors I need to know. 1 second. Heather, would you go grab our trial calendar? I know we talked about this before while in chambers. Separate from that, we're going to put this question off to the side. You also had another request that you mentioned in chambers, a bond modification. Yes, Mr. Reveto?
Yes, Your Honor, we would respectfully motion to modify bond at this time. The purpose of bond is to ensure that an individual appears at court for proceedings. It is not meant to serve as a form of pretrial sanction. While there is debate on the date, all parties agree that my client has been at least at the Wexford County Jail since December 8th, and it is currently May 8th. His wife, he reports that his wife is due to have a child any day now and is a medically complicated pregnancy, or delivery at least. And at the one hand, the court is saying, well, we don't have any proof that he was extradited or the date of that happening for its reasoning on not adjourning and it's setting out of dates. But at the same time, I know the court has previously said, well, since there was an extradition, that's evidence of flight.
Did he waive extradition?
Your Honor, he ultimately waived extradition. I'd have to look at my notes to see. I'm not sure. I think he may have initially said he was going to fight extradition, ultimately waived. The situation is that he was under investigation for these charges for about somewhere between like 4 to 6 months. So he knew this was being investigated when he up and quit his job, moved out of the place that he had, took him and his family to Kansas. Well, he knew this was under investigation. And so then we had to get the U.S. Marshals to go to Kansas to find him, spend quite a bit of money to bring him back here. So I think there's clear reason to be concerned about flight in this case because he knew it was under investigation, chose to leave while he knew the case was being investigated. And so I have great concern that should he get out, if he's able to travel, that he would leave. He also has lived here in this area for a number of years now, but has also lived all across the country in Washington and Louisiana and Florida and Kansas. So his ties here are somewhat limited and he does have ties in other places.
Thank you, Ms. Rivento.
Your Honor, it's my understanding he left. He was under investigation for a Misaki CPS case. That case was resolved. He left after that case was resolved. There might have been something criminal still pending, but it's my understanding he hadn't been charged with it, and the Misaki case had been resolved. Your Honor, people should not have to sit around forever waiting to see if they may or may not be charged for alleged criminal allegations that a separate case with a lower evidentiary standard had already been resolved on. In consideration of that, Your Honor, and again, if the concern is flight, those can be, bond requires the least restrictive means possible. We can address risk of flight with the tether. We can address risk of flight with community corrections check-ins. We can address it through other methods. And we would ask that the court maybe impose those methods instead. I understand the people's concern. I understand the court's concern. But if we are pushing an adjournment for an individual who's saying, no, I want my speedy trial, I want to go to trial, I don't want this delayed, I believe the jury will find me not guilty. We should at least give them a chance at bond if by no fault of the clients, it is being pushed off. Thank you.
All right. Why did he go to Kansas? What drew him to Kansas specifically? Go ahead.
May I consult him?
Yeah, of course.
Thank you, Your Honor. He has informed me that his mother lives in Kansas and she was starting to have dementia and other health issues. So they went out there to be by her. He used to have a business in this area because of everything that happened in the Misaki file and the other files. He says when businesses failed, he wanted a fresh start. He wanted to be by his mom.
All right, so here's what the court is going to do and rule on these last two issues. Ms. House, are you in court anywhere next Tuesday?
I am not.
Okay, thank you. The court is going to reserve its ruling on the motion to adjourn and bond modification today is denied. If you wish to bring it up again next Tuesday, you can, because that's when we're going to have our evidentiary hearing objecting to the content of the 768 notice. All right, and we're going to set it, I'm going to say what time? 9:30 on Tuesday here in the courtroom. Now, that's going to put a pinch, and I know you're probably going to have some difficulty with bringing physical witnesses. That's all right. You may present the evidence through some other means. Now, what that does is it puts the pressure on potentially the defense, which can call its own witnesses, and if they choose to call those actual witnesses, such as CVS, they can go get some subpoenas issued out. And if we need to adjourn it, then they can always request to adjourn and add more time. Then that gives me, because it sounds like I've got to listen to an entire day's worth of recordings, gives me Wednesday to do it, since I'm not here Thursday and Friday. And next week is Monday's busy. Thursday, Friday, I'm not here the following Monday, Tuesday, or Wednesday. Then I leave again. I'm only here for one day that week. And then I'm gone Friday, Saturday, and Sunday. So you've got some very limited time. So I've got 3 days that I'm here between the trial date. So.
Your Honor, my concern is that, you know, a subpoena that I issue today isn't even going to be valid, I don't believe.
No. Which means you can present any information that you want on Monday that can be in a physical form, right? And then I can make a ruling based upon that. Now, if any individuals need to be brought here and the defense wishes for them to be brought here, then they can object. And then if they object, you therefore would need more. Bingo. And then we can address, that will allow the defense to also establish and prepare a brief on the 180-day trial clock window. I need time. I need to know when he was arrested. And then I need to know when he was presented in another court for extradition and when he fought the extradition. And then how many days they delayed the preliminary examination, and need to be able to explain to the court whether that those are accredited. The word is credited to either the prosecution or the defense. Now, they also need to consider probably, and that's all up to them, what other dates are they available? Because this is going to be a 4-day trial. So that's going to require the government, the defense and the government to start thinking, and specifically the defense, because I know Ms. House has a different arrangement with the AG's office. Who is going to handle all your other cases on the other dates? Because by next Tuesday, my staff will have every trial date possible that will cover 4 days. Okay. Now, while the defendant is saying, listen, I really want this and want to push, and I appreciate that, and I do take that into consideration. But what I really, really need to know is exactly on what date does the 180-day trial clock window end? Okay, now that trial clock window is not a solid wall like everybody thinks it is. Okay, yes. And I can, pursuant to the court rule regarding pretrial release, MCR 6.106, I can consider the likelihood of conviction, which, by the way, I will have a pretty good image as of Tuesday when I get to see all this other evidence. And I've been practicing, I don't know how long this house has been, but over 3 decades, and all I've ever done is criminal law. And as a defense attorney, 80% of my caseload was CSE cases. So I get to apply some discretion here. And while you may or may not think about this and that and appellate issues, I do. So, and I guarantee you, the law is not going to say, well, the defendant didn't care and pushed it. And then they're going to say, but the defense attorney should have told him no. So I appreciate that position, but that's not the analysis that I have to go through. So as of today, the court does not grant any bond modification. I will adjourn that till Tuesday as well. So next Tuesday, we've got a hearing set for, and this is going to be probably a whole day thing, starting at 9:30. We're going to be talking about the 768 admissibility. We're going to talk about motions to adjourn. And then we're going to talk about bond and the 180-day trial clock. And Ms. House, if you could please check with your new witnesses or whomever about availability. Now, particularly, you've got a expert witness, and we've already ruled, I've already made a ruling on that, and her availability and witness availability pursuant to Court Rule 6.004 says I may consider witness availability. And an expert witness, I'm going to say here, is a very important witness because of explaining to jurors certain facts. That's already what I've ruled earlier back on April 27th. All right. Anything else, Ms. House?
Nothing today, Your Honor.
Anything else, Ms. Fioravento?
Just for clarification, when do you want the written response to the?
Before we have our hearing.
Okay. Would Monday be enough time for Your Honor?
Yeah, I don't have to write it. I just have to read it. So, all right. Thank you very much. We are adjourned.
Okie dokie, friends. That seems complicated and messy and a poo-poo show, but sometimes that's how it rolls. TCF Live on a Super Friday. Getting ready to close out hour 2 in about 15 minutes. We are just flying through the morning, aren't we? Let's go to Lake County, Ohio. Judge O'Donnell.
And perhaps waive the jury at a later date.
Mr. Deeb. Your Honor, we have already waived time. When this was refiled, we had 22 days left on a speedy trial, and we took care of it. Go ahead and see that.
Okay.
We took care of that right away. We anticipate that we'll be waiving the jury trial, but I have to have that discussion again with my client, and then we'll notify the court that we anticipate that will happen. And we had not approached on the previous filing for any offers, so I believe the offer is just plead as charged, as basically stated. And my client at this time is not going to be pleading going forward to trial.
All right, here. Okay, so I'll give you a jury trial date for right now until such time if and when a waiver is filed of June 15th at 8 a.m. And I'm going to set another hearing for June 3 at 9 o'clock. If there is an offer and he's going to plead, we'll do it that date. And perhaps if he's going to file a jury waiver, we can do it on the record that date. But whatever, if he's going to waive, we got to come in here and do it on the record, and then we'll get a date for a separate date for a bench trial, okay? So I'll make that, for now, June 3rd at 9 o'clock. All right, anything else, Ms. Shepherd?
No, thank you, Judge.
Mr. D?
You said June 15th?
June 15th to jury, yeah.
Thank you, Your Honor. Nothing further.
All right.
Well, that was short and sweet. We don't normally get that short and sweet out of Judge O'Donnell without at least a couple of swear words put in there. Let's go to St. Joseph County. Judge Middleton has some bench warrant arrangements from the looks of things.
Good morning, everyone. Good morning, Ms. Owen.
Good morning.
A crowd has gathered on your behalf. Mr. Keith Stickley is here from the Public Defender's Office. Mr. Daniel Frazan, your probation officer, is here. Prosecutor Angelique Canfield is here, and we've also got someone from the victim advocate team at the prosecutor's office. You got arrested last night on two separate files, 2520220 FY. That's a technical probation violation. And I and the judge supervising your probation. He also got arrested in 252597 for a violation of bond conditions and a charge of domestic assault. Judge Pattison is handling that case, and I agreed that I would do both of these bench warrant arraignments this morning. In 252203, you were charged with assault with a dangerous weapon. It was reduced to a misdemeanor charge of domestic assault. You entered a plea and you were placed on probation. Your original attorney in that case was Casey Strong. Your probation officer, as I indicated, Daniel Frazine, is here. In the second case, you were arrested again for domestic assault in December. Attorney Luke Knopfsinger was appointed to represent you. It was set for a jury trial in February. I'm not sure what happened anyway. Then it was set for March 1st, and I'm not sure what happened, but there was not a plea and there was not a jury trial. I understand you got picked up last night in contact with Gregory Owens, who you're not supposed to have any contact with. There's also alleged to be multiple violations of your probation, including no alcohol, no other assaultive behavior. Mr. Frazine, could you join us, please? Five. Daniel, your screen is frozen. I don't know if you can join us. Apparently not. Where did you get arrested last night? Three Rivers?
My neighbor's house.
In Three Rivers?
Yes.
The prosecutor doesn't often show up for these simple misdemeanor bench warrant arraignments, but they feel strongly enough about this one that they are here. Ms. Canfield, what's the prosecutor's position here?
Oh, thank you, Your Honor. Well, my concern is that we're giving or attempting to give Ms. Owens rehabilitative tools that she obviously is not taken advantage of with respect to the alleged probation violation. And additionally, she's violating bond conditions that are also in place. And this involved not only an admission of consuming alcohol again, but an alleged threat to another individual in the presence of the agent. So this is really concerning behavior. And at this point, I'm going to request, or at least think it appropriate, that a higher cash bond be set or that it be revoked pending a resolution on the other matter still before the court, the 252597 SM.
All right, Daniel, your screen is frozen and I can't hear you or see you, except a picture of your handsome face staring into space.
I can
darn
email
it.
him. Let's see if I can get.
Might be able to have them come here and pull up a cherry's time to go that way.
Yeah, Daniel's frozen. I need his input and I can't see him. So, yeah. Yes. I think it's operator error, but we've got you on the speakerphone. Ms. Owens got picked up last night. Ms. Canfield is requesting that bond be canceled or raised. She's not entitled to a bond in the probation violation case, but I understand that there are some other issues going on. What else is happening here?
Well, she's had several issues with testing. I have 3 positive, 1 dilute, and 1 pending right now. And she has 5 no-shows. And she admits that she's still drinking.
All right, Ms. Owens, I'm going to show a plea of not guilty on the probation violation and appoint an attorney. Your original attorney was Casey Strong. Bond is canceled. Set a PV hearing next week. In the other case, the one in which you're on bond, I don't need to deal with a bond because it's canceled in the other case. I'm gonna set a bond violation hearing. With attorney Luke Knopfsinger. I understand the blood alcohol last night was something like 223. So we're struggling, but you're like a ping pong ball bouncing around. You're not in treatment very well. You're not testing. You're still drinking. You're violating your no contact provisions and allegations. Right now, I just need to hold on to you. So I'm setting both of these for a hearing, probation violation with Daniel. Now, Ms. Canfield, did I also understand there may be another assault charge pending?
I'm going to look and see.
Well, can I ask for what? Why would I have another assault charge?
I don't know. Someone said something to me that may have been another charge pending, so maybe I'm mistaken.
I'm looking, Your Honor.
That's impossible.
Is that domestic violence which she tried to?
I don't. I'm sorry, Mr. Frazine, what were you saying?
She tried to plead to an assault and battery, but judge would not accept the factual basis, and it got kicked back. And I think that's the 2597 case.
Yes, it is.
Yes,
All right.
that's correct. So there isn't a new one. That's the one that's still pending, Your Honor.
Okay. All right, we're gonna have a probation violation hearing regarding the allegations that you continue to use alcohol in violation of your probation. You refused to test, tested positive. Then there also is an issue regarding your bond conditions, which may be a way to resolve that pending other domestic assault case in file 252597. I can't tell why it didn't go to trial in March. I don't know. At any rate, Ms. Owens, you need some clean time and we're gonna figure out what's going on here. So I'll get these, I've got 2 lawyers to schedule, Mr. Knopfsinger and probably Casey Strong. And we'll deal with both of these matters next week. All right, Daniel, we'll see where we're going with this. Thank you. Ms. Canfield, thank you.
Thank you, Your Honor.
All right. All right, you're good to go. Daniel, I'm not sure what's up, but I'll hang up on you. All right, now this next guy, Mr. McNett, I'm gonna forward to you the email I got from Tiffany, Tiffany.
Thank you. Got it. Ain't doing it wrong.
Good morning, sir. Are you Kevin Lee James McNett?
Yes, Your Honor.
I'm Judge Middleton. Also present here is the Chief Public Defender, Mr. Keith Stickley. You got arrested here this morning at the courthouse on a bench warrant. The file number is 25494FY. In that matter, you were charged with possession of methamphetamine. Now let's take a look at it. Let's see if they put this in my queue. They didn't. So let me dial it up here. This all just sort of came in on the fly. I was in the middle of landlord-tenant cases and you come rolling in 10 days late.
I apologize, Your Honor.
All right, let me look at the actual complaint. As I said, I didn't get much of a chance to prep this. It was just handed to me while I was in here on the bench. The charge alleged that on or about January 27th of 2026, that you did possess methamphetamine as a second or subsequent offense, as a fourth habitual offender, making that theoretically punishable by up to life imprisonment. It all has to do with a pipe, which ain't the crime of the century, but the way it all stacks up. So you pled not guilty. You posted a bond of $7,500 with the bonding company. And you posted that in April. They set a pre-exam conference for May 5th. and you failed to appear. I did an immediate bench warrant. You have $1,330 worth of unpaid fine and costs. As far as I can tell, you never made contact with pretrial services, at least as of May 5th. And you didn't show up. So you called 2 days later. And they were supposed to be working on a bench warrant. He said you could come in tomorrow morning as warrant may be entered by noon. And Judge Middleton could choose to recall the warrant. I was gone for 2 days. And so apparently you said you would come in tomorrow morning, which is today. So somebody made arrangements for you to come present yourself, and I wanted an immediate bench warrant. I also contacted Community Corrections and they indicate as of yesterday, Friday, you contacted Community Corrections. There should have been a bench warrant for your arrest, but it got held up by staff. And then you come rolling in. So when we were here last Tuesday, I was here, Mr. Bush was here. We had 31 cases. You, at that point, had not made contact with Mr. Bush and had not made contact with Community Corrections. Then you call 2 days after the day you're supposed to be here and say, hey, I missed court. So then I didn't realize staff actually told you to come in here this morning till I just read the pleadings. So have you contacted Mr. Bush?
I called him yesterday. I didn't realize I'd missed my court date until yesterday, and I have been contacting the MDOC every day that they've told me to.
Well, you started that on Friday. Oh, let me look at that. Maybe I got my days mixed up because this Caesar said
because of the
you did check them
electricity
with this May 1st. All right, so you did. So why didn't you show up for your court hearing?
I have a lot going on at home. My mom's got stage 4 cancer. I've had my pivotal appointments and work, and it slipped my mind. I didn't realize it was so soon. My mom's starting.
All right, so you hadn't called your lawyer as of last Tuesday, but you have called him since?
I called my lawyer yesterday. It was the first time I called him. I've never had to contact my attorney first. They always meet me at my first court date.
That's not how it works. We give you instructions to call your lawyer. It's a pain in the neck when you show up when there's 31 cases pending and say, hey, I want to talk to my lawyer. Plus you got $30 worth of unpaid fines and costs. Where are you working?
Precision Wire.
In Three Rivers?
Yes, sir.
Are you living in the trailer park?
Yes, sir.
You can walk to work from there.
I do.
How long have you been at Precision Wire?
This will be my 4th week.
Did you actually speak to Mr. Bush?
No, I had to, I tried to find this number on the number, but it was giving me the wrong number. I contacted Tracy Chavez. She gave me his number. I called and got a machine.
Well, he's here in court often. He's only been at the same address for about 80 years, give or take. His father started the practice before him. It's been the same number, 651-5380 for probably 80 years. So it slipped your mind that you were supposed to show up for court. Although apparently you had contacted community corrections prior to the hearing on May 5th. Let me look at a couple things here.
I thought my court date was this week.
Yeah.
And it just makes my skin crawl when people say, I thought I'd wait and talk to my lawyer at my first hearing. It just causes all kinds of problems. As I said, there were 31 cases that day. And I go, here I am, ready to talk about my case. That's not how it works. Every single case for next Tuesday is Attorney Truckee. Laura, any luck with Precision Wire?
What's that?
We're checking with Precision Wire to see whether they actually work there or not.
Okay.
What do you have to say to that?
I was gonna say I have a check stub in my wallet, but I left my wallet in the car.
Okay. All right, thanks.
Second shift too, you need to know that. And talk to Mark a little bit.
Oh, he's hard to get a hold of. Cause what? Oh. All right. Mr. Stickley, have any input here?
Your Honor, it sounds like maybe we got off to a rough start. I think he is trying to comply. It's the only input that I would have at this time. I'm sure the gentleman would prefer not being in jail. If he is with community corrections, it looks like he started checking in. Maybe we could try a redo and see how he does. That's what I would have.
All right. The easiest thing to do would be just let you sit in jail. You are working at Precision Wire. You're within walking distance of your house. Did you have to take a urine test to get hired at Precision Wire?
No. But I drug test with parole. I'm on parole.
You're still on parole?
Yes, sir.
Gee, I didn't know that. Who's your PO?
Tracy Chabot.
All right. Mr. Bush is not scheduled to be here next Tuesday. I'm going to reinstate your bond and your community corrections conditions remain in effect.
All right, thank you, Your Honor.
Yeah. You are to contact your lawyer.
Yes, sir.
If you don't, I'm going to cancel your bond at the time of the pre-exam. If you show up on May 19th and haven't talked to your lawyer, I'm going to cancel your bond.
Yes, sir. I'll call him as soon as I get out here. I'm gonna set the pre-exam conference for May 19th, 2026 at 8:30. If we need a preliminary examination, it will be May 26th at 1. This is a very serious charge. It's a drug double with a habitual, which makes it a mandatory life case. Plus you're on parole. I didn't realize there was a parole ramification to this as well. But it all has to do with a small pipe and some residue. I don't know if I tested you today, what the test would show. Probably test you when I see you. I tested yesterday. You tested yesterday? Yes, sir. You've been around long enough that it don't just slip your mind that you're supposed to show up for court. This is a huge pain in the neck for us. Sir, it was a complete mistake. All right, so you're to be here after you talk to your lawyer on May 19th at 8:30. Yes, sir. I'm gonna recall the bench warrant and we'll have a pre-exam conference at that time. If you don't show up, I'm gonna set the bond at $10 million and contact your PO and your bonding company. You've also posted a substantial amount of money, which could have been forfeited. I'll reinstate that bond and we'll give you a notice. Tuesday, May 19th at 8:30. Yes, sir. No, sir. No. All right, I'll see you then. All right, thank you. All right.
Okie dokie, friends. We're now in hour 3 of TCF Live. I really don't know where the time goes. This goes by so fast. Let's go to Texas. Judge Stevens.
Are we, or are we kicking it down the road? Oh, well, I know he's playing, but so bad. His girlfriend might have a problem. Yeah.
Very much around maybe so. She probably was.
Man, there's a lot of marked outs.
I sent somebody right behind.
Yeah.
I mean, really close.
Thank you.
Down.
Okay, on this, okay, it's reading enhanced to a 3rd degree. That's 3rd degree punishment. It's a state jail felony.
That's correct.
Correct, sir.
Enhanced to a 3rd degree
It was, yes.
punishment, right?
Yes, when he was put on probation for it, correct.
Okay, that's what it's because it says enhanced to 3rd degree only. That's what we got.
And there's another asterisk down at the bottom that details the 3rd degree felony punishment range.
I understand that, but there's nothing that shows this is a state jail felony.
Judge, the paperwork itself is on state jail felony paperwork, which is why the additions were made for 3rd degree.
Okay, but what I'm going to add is state jail felony and then pick up with enhanced to 3rd degree punishment. Okay, so. Can't touch the pad or else it does swing. So that's why I have this little. Okay. And then you did that, good. 5, 6, 5, 4. He's gonna get revoked and it's 4 years in each case?
Yes,
To run- To run together?
Yes.
Okay.
Your Honor.
Yes.
All right, we will take this numerically, beginning with 24 CR 1654, and then we will go 24 CR 2193. These are both first amended motions to revoke probation, stating the state of Texas versus Darren Adam Banks. You or Mr. Banks?
Yes.
And you hear with your attorney and the state's attorney. Does the defendant waive a formal reading of these first amended motions to revoke probation? In each of these cases, can we proceed in summary?
Yes, Judge.
Each of these similarly state, sir, that on March 3rd, 2025 in this criminal district court of Jefferson County, Texas, you were placed on, you were sentenced to 10 years in prison, probated for 10 years for the state jail felonies of theft of material, and it looks like it must be metal of some sort, copper, in 24 CR 1654, and burglary of a building in 24 CR 2193. And in each of those state jail felonies, you were sentenced to 10 years in prison, and that was suspended, and you were placed on probation for 10 years. Is all of that true and correct for each of these two cases?
Yes.
Let's see. Was it, what's he pleading to? Is it evading arrest?
But if you want him to do different violations, we can do whichever numbers you want. I put 1 and 2, but
What happened in the evading arrest or detention case? Is that pending somewhere in another court?
It's pending in misdemeanor court.
Has that been disposed of?
not to my knowledge, Judge.
Failure, and the failure to ID,
Same thing, Judge.
that's,
Same offense state, both pending in
what do y'all
misdemeanor.
want to do? Just,
I want to plea on counts 5 and 6.
It makes no difference to us.
is 5 good?
That's fine, Judge.
All right, allegation, and raise your right hand. Did I already?
You did not, Judge.
Do you solemnly swear or affirm the testimony that you are going to give today during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Our Lord, and is this all true and correct, that in each of these two cases, you were sentenced to 10 years in prison, probated for 10 years, and those were state jail felonies, enhanced though to punishment as though they were a third degree felony because of the prior convictions that you have?
Yes, sir.
All of that's true and correct, sir? All right, allegation 5 in each of these motions to revoke probation. Then these are first amended motions to revoke probation filed May 6th. Well, that's quick. You just got,
Yes, sir.
just, okay. Do you solemnly swear and affirm that you are waiving any additional time that you may have to prepare for this hearing? Because this was filed, these motions were filed recently, and we are having a hearing here today, which is very quickly after the motions to revoke probation, which are fine, but you have about 30, I think you have at least 30 days
10.
under the law.
10.
You have time, 10, 30, 10 or more, to prepare and talk to your lawyer and think about this. You can also waive that period of time and move forward today if you wish, if you feel like you've had enough time to think with it, you've discussed with your attorney, and you are ready to proceed today. Is that what you want to do?
Yes, sir.
Okay, are you making that decision voluntarily and after discussions with your attorney here?
Yes.
Ms. Manaldi, all right. Allegation 5 states you committed the offense of evading arrest or detention on or about March 19th, 2026, Jefferson County, Texas. And this is an allegation in each of these two motions to revoke probation. And they are allegations number 5 under the first amended portion. And these also state that these allegations of evading arrest or detention in each case, those are violations of condition 1 of your probation order, which states do not commit another crime. Is all of that true and correct?
Yes.
Are you pleading true to each of these allegations voluntarily and because those allegations are indeed true?
Yes.
Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that's enough to grant the motion to revoke probation? Your probation can be revoked and you can be sentenced to the full range of punishment, which is no less than 2 nor more than 10 years confinement in prison. Knowing all of that, do you insist on pleading true today in each of these 2 motions to revoke probation to allegation 5? I find you pleading true to allegations of violations in each of these motions to revoke probation voluntarily, knowingly, intelligently, and because they are true.
Yes.
There's an agreement that states that your probation would be revoked. You would be sentenced to 4 years in prison and you would be given credit for all time you have served in accordance with that. Is all of that your understanding? Is that true and correct?
Yes.
Are you, are you agreeing to that voluntarily and after discussing all of this with your attorney?
Yes.
Yes.
Yes, sir.
You know, I'm looking here at what this has. I gotta change the count. If I can. I've got the funny pen. I'm going to show you what's marked in each of these cases. That states Exhibit 1. Did you sign those documents? Understand them? Discuss them with your attorney? Are the contents true and correct?
Yes.
States Exhibit 1 is tendered into evidence
No
in each case without objection admitted. Among other things, these state that if I follow this agreement, you understand you are waiving all rights of appeal. I'm going to do that in each of these cases. Anything further to add?
No,
If nothing further, I'm going to make the following findings. And then in each of these 2 first amended motions to revoke probation here, I find that you have pleaded true to allegation 5, which is committing the offense of evading arrest or detention on or about March 19th, 2026 in Jefferson County, Texas, which violates condition 1 of your probation order in each of these cases, which states you shall not commit an offense while on probation. Your pleading of true voluntarily, knowingly, intelligently is enough to grant these motions to revoke probation by a preponderance of the evidence or greater. These first amended motions to revoke probation are hereby granted and your probation is hereby revoked in each of these 2 cases. And in accordance with these agreements, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years in each of these cases. These sentences shall run concurrently. Is that your understanding of the plan? And that shall be carried out. Anything else?
No, yeah.
That's all. Thank you. Yes.
Alrighty, friends, TCF Live on a Super Friday. My name is Dan. It is great to have you all with me. We've got about 35 or so more minutes to go. We're going to go to Judge O'Donnell in Lake County, Ohio, and then after that, we'll go to Dungeon Court.
First violation, tested positive for marijuana May 19th of 2025. You understand that charge?
Yes, Your Honor.
Failed to report June 2nd of 25 and thereafter. You understand that charge?
Yes, Your Honor.
March 24 of 26, tested positive for marijuana. You understand that charge?
Yes, Your Honor.
Ms. Tomasic?
Thank you, Your Honor. I spoke with Mr. Howard. He indicated today he would like to waive his final hearing, plead guilty to the charges, and we're prepared to proceed with sentencing. Thank you.
Is that what you want to do?
Yes, Your Honor.
What's your plea to those charges?
Guilty.
accept your guilty plea and find you guilty, Ms. Tomasic.
Yes, thank you, Your Honor. We would just like to ask the court today for any leniency in sentencing. Your Honor, when this case did occur, Mr. Howard was much younger with regard to not showing up to probation and the marijuana violation. I did speak with him about that. He indicated back in May of 2025 when he when he was positive for marijuana and didn't report in June, he was scared to report. He was scared because of the situation. He didn't want to be back in the courtroom, Your Honor. In speaking with Mr. Howard, he has since been working. He's had on and off jobs in factories. He indicated it was a little difficult to keep a job due to the felony on his record. Prior to getting picked up, he was working at AMCO. It was a coil factory, so he was doing work there. He was working full time. Your Honor, he does have aspirations. He does want to become a barber. That is his goal in life. He does have a great support system. He has family and friends here in support of him today. Thank you.
What do you want to tell me before I sentence you?
I mean, I don't really want to too much get run around. I've been dealing with this case since 18. I just really want to get it over with. You know what I'm saying?
Want to get it over with?
Yeah. As far as the back and forth time, I don't catch new cases. This been doing time on the same case. I work a regular job. I don't get into bad activities. I don't sell drugs. I don't tote guns. So I know if I do my time and get it over with, I won't never step foot in no type of facility like this again. I just want to get it over with, Your Honor.
And then what?
And start my career as a barber.
Well, this was a felonious assault that was reduced to an attempted felonious assault. He was sentenced October 18 of 23. Ordered to do the jail treatment program and continue with Ohio Guidestone. No drugs or alcohol. So then you likely got out in January of 24. Test positive for marijuana. February 5th, 22nd, March 4th, March 18th, and April 1. So we kicked it out a couple months to see if you'd stop using marijuana, and you didn't. So you were violated, as well as picking up a theft charge out of Mercer. So you came in for your hearing June 12th of 24. I kept you on community control. Ordered you to go to NeoCap. Went to NeoCap. Got out March 18th of 25. May 19th of 25, test positive for marijuana, and you just stopped showing up. Apparently you kept smoking marijuana because you tested positive once you were arrested. So you haven't paid one bit of attention to anything in this case when you've been on probation. So you are no longer amenable to community control. And make that decision having gone back and reviewed again the pre-sentence report and the drug and alcohol evaluation and the victim impact statement, which I'm certain you remember that it was a pretty severe injury that this guy received at your hands. But I put you on probation anyway. And you determined that you didn't want to do anything, you just wanted to continue to do whatever you wanted. So you're going to continue to do whatever you wanted. So having reviewed everything and listened to what you have had to say, listen to what counsel has had to say, Since you are no longer amenable to community control, I'm going to terminate your community control. I'm going to sentence you to 35 months in prison with credit for 424 days. When you get out, you might be on post-release control for up to 2 years under the parole authority with conditions. If you violate the conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months or the time left under post-release control. The costs are assessed. Anything else?
No, Your Honor.
Ms. Tomazik?
Nothing further, Your Honor. Thank you.
All right.
Alrighty, friends, it's that time on a Friday where we engage in our TCF guilty pleasure. Carpets the color of blood, the screams in the background, the lighting from the Cold War era, the spookiness, the scariness, the damp, mildewy surfaces. They believe in Appalachia that justice is best served in a cold, dank basement. Ladies and gentlemen, I give you Dungeon Court.
All right, this is State of Ohio versus Sean Williams, CRB 26-217 A through E, CRB 2574 A and B, CRB 2650 A and B. This is Mr. Morford's case, set at the trial.
Yeah.
Deborah Williams here?
She's out there with the grandbaby right now in the car. If you need her, we can go get her.
I think that it was a good report, if I'm not mistaken, so we're happy about that. We just wanted to continue. Let's do June 26th for pretrial at 10 a.m.
Judge, could you move that up maybe a week or so? That may be.
22nd?
That may be my last day.
Okay.
If we could do it.
Let's do June 22nd. Is that okay?
That may be my last day.
Oh, okay. June 15th.
Good. 15?
Yes, sir. Thank you, Judge.
At 10?
10 a.m.
John, we're ready to start calling some inmates that are left at home.
All right, gonna call some more arraignments.
State of Ohio versus Timothy Cavalier, case number CRB 26264. No, they're the ones that called us and told us to add him.
Well, they can go to the end of the docket and we'll get him on Zoom at the end of the docket.
State of Ohio versus Tracy DeMint, case number TRC 26725 A and B.
this is State of Ohio versus Tracy Dement, TRC 26725 AMB. Mr. Dement was alleged on or about May 7th, 2026. You weren't up here, so I'm going to go through your rights before the court at this point. So I'm going to go through your charge with you, and at the end of this, it looks like you've had 5 priors, so I believe this would make this a felony, and it would be a felony of the 4th degree or felony of the 3rd degree, a felony of the 4th degree. I don't know that it's necessarily charged as that, Mr. Kiel. It's just charged as a regular ticket, so I don't know.
Well, we intend to file a long form alleging a felony, but and we're a little short-handed today, so we've had some problems trying to keep up, but we'd like the court to recognize that that is the fact.
Okay. All right, so Mr. Dement, we'll go through with this, and where it's a felony, I cannot take a plea on this from you today. But we'll go through it, and at the end of it, I'll go through the rights for the court here. And I'd like to remain silent for recording here today, and anything that you would say that is against your interest could be used against you. You have the right to have an attorney. If you can't afford an attorney, I can appoint one to represent you at no cost. You have the right to have reasonable bail set on the matter, and you have the right for the state to hear each of them, every element of the defense charge beyond a reasonable doubt. You understand your rights before the court. All right. Mr. Dement is alleged on or about May 7th, 2026 in Union Township that you were operating a motor vehicle under the influence of alcohol, drug abuse, or a combination thereof, and that you refused a test. So there's a violation of Ohio Revised Code Section 4511-19A1A, which is a felony for ODI. Maximum penalty on that is, I believe, up to 18 months in prison and up to a $5,000 fine. There is a B case, or as part of the A case, it's also alleged 4511-19A2, which is criminal refusal, which is a refusal of prior, and that would also be the same level offense with up to a felony of the 4th degree, up to 18 months in prison and up to a $5,000 fine. It's also alleged in the B case that you drove left of center, and that's an alleged violation of Ohio Revised Code Section 4511.29. That is a minor misdemeanor. Maximum penalty on that is up to a $150 fine and court costs. You have money to hire an attorney? Okay, so you're intending to hire your own attorney? Okay. Are you working currently? All right. Paid hourly? All right. What's your annual income? Okay. What's your annual income? What was it this past year? Okay, then you definitely aren't going to qualify. All right, so Mr. Hill, do you want to be heard on the matter of bond?
The state would ask for a $25,000 cash assurance bond.
Okay. Mr. Dement, I know you don't have an attorney, but I'll give you an opportunity to argue bond for yourself today. If you hire an attorney, they can always come back and revisit that later here. So what the state is asking for a $25,000 cash security bond, which means you either post $25,000 with the court, or you can call a bondsman and pay the bondsman a fee to post the bond for you. Is that a bond that you think that you could make? Okay. And I would let you argue for something lesser if you wish. All right. Okay. Well, one thing that I have seen over a long period of time is that you typically do show up to court, but I do want at least a cash surety bond on you. So I'll set bond at $5,000 cash surety.
We'd like an order that the bond be dependent on him not driving.
I was going to make that as a condition of the bond. And a condition of your bond is that you can have you cannot operate a motor vehicle of any sort their independence is not, you understand?
Was it really?
I'm going to go ahead and set a preliminary hearing for May 15th.
You're right.
All right, Mr. Dent, if you make bond, you'll need to come be back here at May 15th at 10 a.m. If you don't make bond, then you'll be in custody of the sheriff, and they'll take care of that at that time. And then we'll see if you've hired an attorney by that point. If you have hired an attorney, stay in contact with them. They can always request that this be moved. Potentially, it doesn't meet their schedule. But otherwise, unless you hear otherwise, then at that point, you'll be back here on May 15th at 10 a.m. All right, thank you, Mr. DeMello.
What's the date, Your Honor?
May 15th.
Thank you.
State of Ohio versus Dustin Mace, case number CRA 26265. Dustin Mace.
I've been in contact with his family, and they wanted me to discuss going to treatment. And I have talked with him, and if it pleases the court, if it's allowed, then he will be coming into services with us upon whatever you say.
Okay. This is case number CRA 26265, State of Ohio versus Dustin Mace. Mr. Mace, it's alleged that on or about May 7th, 2026, you did knowingly cause or attempt to cause physical harm to Megan Mace, a family or household member, and just said Dustin Mace having been convicted of a prior domestic violence offense in violation of section 2919.5A of the Ohio Revised Code. Domestic violence, that's a felony of the 4th degree. Felonies of the 4th degree carry a maximum penalty of up to 18 months in prison and up to a $5,000 fine. Do you have money to hire an attorney?
No, not at the moment, sir.
Are you working currently?
No.
All right, so I will appoint Attorney Luke Steyer, if he's still here. Okay. Then I'll appoint Attorney Stratton, if he's still here. Looks like you may be getting some work, a workout on Mr. Stratton.
Yes, sir.
All right, state wish to be heard on the matter of bond. Mr. Stratton, this is an F4 domestic violence.
I'm going to ask for a protection order, and we would not be opposed. I'm sorry, what degree is it?
Felony 4th degree.
Okay. Sorry, we're a little overwhelmed today.
She said that if he wants to get out on bond to go to an inpatient treatment, if he wants to get assessed,
Okay.
and then order a protection order.
Yeah.
Yeah, that's what it.
All right, so there is an indication here that Mr. Mace could benefit from treatment. And so as long as he would agree to be assessed and to enter into a residential treatment program, we would not oppose an OR bond. And then the issue of how we're going to deal with the fact that it's a felony, we'll have to address at a later date. Otherwise, we want to have a cash or surety bond.
He's okay with it.
Yeah, you're good.
Has he been assessed yet?
No, he is approved, but I need to do a pre-screen. I will go back there. But from what I know, I'm almost positive it's 100%.
Okay. What I'll do then is I will give Mr. Mace a $5,000 OR bond with the condition that he be released.
Another issue, Your Honor, I've become aware of is that he's on methadone. So I don't know how that plays into it. Might require.
He wouldn't be able to come into services with us on methadone, but if he's willing to. Okay, we'll switch him to something else. Yes.
We have $5,000 bond, but as a condition of that, he'll be released only to focus for residential treatment, and that is pending the assessment, but assuming that the assessment goes the way that we believe it will go, that's what will happen. In the event that something comes up, let us know today.
Yes.
And we will recall the case, but otherwise, going to be, of course, ruling at this point. And Mr. Mace, the temporary protection order is going to issue for the benefit of Megan Mace. That means you can have no contact of any sort, whether it be directly, indirectly, over the internet, having someone call on your behalf, anything, with Ms. Mace up until such time as further will be court. If she may come in later and say she doesn't want that, but presently, that's when your court order, she can have no contact up until the court will decide otherwise. You understand that? Okay. All right, I'm going to set you back. Mr. Stratton, let's come back. You waive time on the phone and yes, all right, so I'm going to set you back June 15th. That'll give you some time in your treatment provider to make sure that things are going well and we can get a report. And that'll be a preliminary hearing.
State of Ohio versus Edward Ferris. Case number CRB 24537. Edward Ferris. June 15th.
You get yours to be
All right, this is State of Ohio versus Edward Ferris, CRB 24537. Mr. Ferris was present after being arrested. Well, anything other than in the report that you'd like to speak about?
Sir, I think that this was a bad judgment call. We have a no tolerance policy. However, do I think that he should sit in jail or that he should continue treatment? I absolutely think he should continue his treatment. And I did find another treatment provider, if the court allows, that will take him into services.
Okay. So I presume you're willing to take him into service?
Yes, we're willing to accept him.
All right. Mr. Ferris, anything that you would like to say for yourself here today? And I've read the report. Not going to discuss that openly on the record, but is there anything you want to say for yourself? Okay, I mean, is this something you want to be serious about? Because what's in the report's pretty serious. I will, I'm gonna set you a bond today. You're here on bond revocation, but I'm going to, let's see. All right, I'm gonna set you a bond at 5,000 OR to be released only to hometown. And I'm gonna caution you, Mr. Ferris, that if you do not take this seriously, then the time that you have over your head and any unpaid fines and community service that may be out there is just going to be imposed. Because I'm not gonna put up with any more nonsense. I have doubts that you're taking this serious, and this is kind of against my better judgment. I hope you go there today and not spend anything to it. Quite frankly, you should probably spend the next week sitting in there thinking about your actions. And I'm going to cut you a little bit of a break today to give you an opportunity to do that. If you either run or you don't do what you're supposed to do, okay. And I don't see anything in the record that would give me any indication of what you're looking at doing. But I just want to be very, very clear that if you mess up, you're just going to spend your time. Do you understand that? All right, so now you've said it on the record. We know, you understand, and so there's not going to be no chance. Okay? All right, so the bond will be 5,000 OR, released only to hometown recovery for residential treatment.
Thank you, Your Honor.
Thank you.
Well, Your Honor, what is your appointment date?
Already set for June the 1st for a pre-trial.
Let's keep that date, June 1st, for pre-trial. All right, good luck, Mr. Ferris.
State of Ohio versus Jared Merritt. Case number CRB 2462, CRB 22-1036 A and B, CRB 22-1063, CRB 22-920, CRB 19756. Set for review, Your Honor.
It's the State of Ohio versus Jared Merritt, CRB 2262, CRB 22-1036 A and B, CRB 2263, CRB 22 Line 20, CRB 19756, CRC 2206, CRB 2238, and 50.
Was actually set for Monday for review. He was housed in Zane County at the time, so.
Okay. And Mr. Meredith, I believe you have an issue presently in common pleas court, is that correct? Who's your attorney on that?
Yes, Scott, but he's not really doing much help for us. I'm trying to find me a lawyer.
Okay. Mr. Scott?
My wife's got scheduled an appointment with one day.
Okay.
Talk to.
And Mr. Scott is presently your attorney, and so we're just here on a review. And I presume that you're being held on the common pleas case right now. Is that what you're being held on? Okay. So I'm just going to set you another review hearing because it may be academic at this point anyway, depending on what happens with your common pleas case. So I'm going to set you a review hearing for June 22nd. See you back then.
State of Ohio versus Logan Rife. Excuse me. Can't call that case yet. Waiting for Mr. Smith to get here, so we'll look at some other cases.
And Mr. Smith has messaged me and ended up and informed us that he's hung up. He may or may not be able to get here, but I told him that he's going to try to get here as soon as he can. And if he can't, I believe he's spoken to someone to stand up for him on his cases. But I think he's going to try to get here as quickly as he can.
He's got a number of cases. State of Ohio versus Brian Elliott. Case number CRA 25-525. Mr. Holt's case.
This is State of Ohio versus Brian Elliott, CRA 25-525, CRA 25-527. This is Mr. Holt's case, set as a preliminary hearing, and I got a note there that we may just finalize this.
Yes, Your Honor, we have the certificate here. He has completed, and Your Honor, would you like to see it?
You can vote. Well, congratulations, Mr. Elliott.
Thank you.
Very commendable, Your Honor. And even back a month, 2 months ago, it was discussed when he was here in court that he was close to being completed at that time. So we're satisfied that he's done everything he needed to do in order for us to live up to our end of the bargain, which was to dismiss the charges.
Well, sounds like the state is willing to dismiss all charges against you, Mr. Elliott, and I'll happily grant that, considering you completed your treatment and all you've done, so congratulations.
Thank you.
You're finished up here.
I appreciate y'all giving me a chance to do everything right, you know. And you saved my life. You really have. That I appreciate it.
Glad to hear things are going well, and you know, hopefully going forward you can continue to keep your sobriety and continue to do all the things that you've been doing already and show what you can do.
Yeah, I'm gonna pursue myself in treatments. Maybe help somebody along the way.
That'd be great. All right, Mr. Elliott, you're free
Thank
to go.
you. Thank you.
Alrighty, friends, that will do it for today and for the week. Obviously, we'll post some stuff over the weekend, but we won't be live until Monday. That'll be 9 a.m. Eastern, 6 a.m. Pacific. A half an hour earlier if you're a channel member. Yes, on Monday, the pre-show will come back for channel members after a 2-week hiatus, and I'm looking forward to that. We can start doing some funny stuff again. So if you are a new channel member, do join us for that. It's a good time. But yeah, I appreciate all of you. It's been a great week. I hope everybody has enjoyed it as much as I have. Go have yourselves a good weekend. I will try to do the same and look forward to seeing you all on Monday. Take care. God bless.